May I please, Your Lordship?
Yes.
Madam, in
One
item
second.
number 12.
Item number 12.
Yes, we have filed our objection in the IA today. And the
Actually, you were
objection
supposed to file your objection by Friday, I believe.
Yes, yes,
that
my
was
lord.
the order.
My lord.
And then today you have filed it.
Yes, yes.
And
But we have served an advance copy on the other side. And today we have travelled from Gauhati and today we have filed. So, my lord, the objection may be called for, my lord.
okay, you give a
My
request.
lord.
Objection.
Already?
There are no mentioned matters today. Good.
No. This one will be called later.
Call for the objection that they have filed.
May I please, Your Lordship?
Yes.
May we please to mention admission number 6, Your Lordship.
Item number 6.
Yes, Your Lordship. Your Lordship.
It's a contempt petition.
Yes, Your Lordship. The case of the petition is under consideration. However, there were some lapses of the on the document, and therefore the
In the
department
last
was
order only it was reflected that the process was on for,
yes, yes.
Last
for
two orders.
identifying the vacant post and then
No, we have identified the vacant post and we have sent it, Your Lordship. However, I received a letter that there were some lapses on the document, and therefore the government has written a letter to the. I just received on Friday, Your Lordship.
Okay.
So,
Okay.
An amended cost title, you have impleaded someone, or I think the petitioner. Yes.
No, we haven't filed any amended petition.
Is it? But in the order it is reflected amended cost title was not filed.
Perhaps on the earlier date.
Regarding? Anyways, okay. You want time, and
I'll
so
check
that.
the files, yes.
Let the matter be reached, otherwise. Let's see what is.
Your Lordship, I will have my feet on the other court also. Your Lordship.
Acha, okay. You want some more time so that the
Yes,
process
Your
is
Lordship.
completed.
Yes, Your Lordship.
If a copy of the letter can
Yes,
also be
yes.
furnished to me.
Yes. Yes.
You can file an
I
affidavit.
can give a copy to you.
No, you file an affidavit bringing into
That-
record all this. Okay. Ms. So-and-so appearing for the government respondents.
Yes, Your Lordship. For all the contemners, Your Lordship.
Acha, for all the contenders, praise that she has received certain instructions as to the the post being identified as well as for complying with the directions.
Yeah, no, Your Lordship, there was lapses on the documents, Your Lordship. The department has not sent the proper documents. So the government has written a letter to the department to send all the relevant documents, supporting documents, so that the case of the petition can be processed, Your Lordship.
Okay, fine. Ms. So-and-so prays that she will file an affidavit wherein she will annex all the required documents in order to show that the direction has been complied with, or in
The case
process
of the petition are in process, Your Lordship.
that the compliance of the order passed by this court is in the process of completion. List the matter after 2 weeks.
Your
And
Lordship,
in
if
the
it can
meantime-
make after 4 weeks, Your Lordship, or 3 weeks or 4 weeks, Your Lordship, because Your
4 weeks
Lordship,
is too long.
then 3 weeks, Your Lordship.
3 weeks, list the matter after 3 weeks. In the meantime, so-and-so will file the affidavit as stated above.
Deeply obliged. May I please, Lordship, I beg to mention item number 18. This is a contempt petition, Lordship.
18.
18, 1-8.
This has come up for orders. Let's see why it has come up for orders.
Lordship, I have not filed my vakalat also here. And we
Achha.
have to file my vakalat. I have been instructed to appear before the private respondents.
Oh, you were on the last occasion only. You were supposed to file your
Yes,
vakalatama.
right.
And
They are from their Delhi, Lordship.
Achha.
It's sometimes
Still you
called-
have not.
Yes, Lordship.
And the respondents were also supposed to file their AO. Respondent 1.
No, I'm appearing for the respondents.
Oh, you are for the
For
respondent.
the respondents, Lordship.
Okay. Mr. So-and-so,
Yangarwati, this is private case is Yangarwati.
praised before this court that he has not filed his vakalat nama and would file the same within a day or two.
Within 3 days, Lordship. They
within-
said they will transmit it by post.
Okay, within 2 or 3 days.
No, not this, weeks. After that, I have to file my, if necessary, I have to do it.
I can get you. You have already filed your
I have
vakalat.
not filed my vakalat, decided it is under transmission by post. So
Achha.
I don't know when I allocate.
Okay.
So that is 3 weeks, Lordship.
Acha, acha. He praised that he would file the vakalat nama within a period of 3 weeks.
Yes, Lordship.
List the matter after 4 weeks.
Much, Lordship.
And in the meantime, you file your AO also?
Yes, Lord.
And in the meantime, it is also prayed that he would file his affidavit in opposition
Yes.
as directed in the last order.
Much obliged.
Please, Your Lordship.
Yes.
Lordship, I'd like to mention item number 9, Your Lordship. I'm
Nine.
preparing above to the leading counsel, Nurul Hassan, with a consensus prayer from the respondent number 2.
Huh.
Both the leading counsels aren't disposed today, Your Lordship. So this matter can come up on 11th of August, Your Lordship, on a consensus prayer.
Otherwise, this has come up for admission, you could have done it.
Lordship.
This is, I think, for quashing of the FIR.
Lordship.
You can do it.
Lordship, the leading counsel is an assistant lawyer, Lordship.
Mr. So-and-so, prays that the leading counsel has some difficulty in doing the case today. List the matter after 2 weeks.
On
Or
11th
I'll
of
give you a
August.
date. Huh?
11th of August, Lordship.
Yes. List the matter on 11th of August.
Much obliged, Lordship.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention item number 23.
23.
Hearing matter 23, Lordship. Lordship, if this matter may come out after 2 weeks, Lordship.
But see, it is 2022 matter. 3 years have gone by. Do it.
Yes, Lordship, I need certain more instructions from my clients, some certain doubts.
What instruction you need after this? But 23, right?
Yes, Lordship.
23, I think the CGSC was to file affidavit. On the last occasion,
Yes, Lordship, actually, they are also on main party. Actually, they are supposed
you
to
are
be filing
appearing
an
for the
affidavit.
central government? Yes, you are supposed to file your affidavit.
At the last occasion, I tried to go back, I'm not going to file it.
Oh, acha. Otherwise,
Lordship,
it's not
actually-
reflected. In the office note, it's
Lordship,
reflected.
actually, I was not present on that day, but actually, they are the financing authority. Now, the matter pertains to the compensation
Okay.
in the road construction.
Uh-huh.
In fact, the compensation has been, I have received the compensation, but the damage caused to the property does not commensurate to the damages.
Acha.
So,
You have not
aggrieved-
got the proper amount.
Yeah, proper amount. I'm aggrieved by this.
So it is you who have to.
So, the central government is also a necessary party since they are the financing authority.
They are not filing AO, but they will be submitting orally. That is what he's saying.
Yes, yes.
So you will not be filing AO.
Yes, I'm not filing it. Coming this
Acha.
Friday, Tuesday.
Okay. But then when will you do it?
2 weeks time may be given.
22 matter. I'll give you a date. No further adjournment after that.
With 2 weeks time, Lordship.
I'll give you a date.
There you go.
Do it on that day. As prayed for by Mr. So-and-so. Oh, as not as prayed for. Mr. So-and-so has prayed before this court that he may be given 2 weeks time. As he is not prepared with the case today. Mr. So-and-so, appearing for the central government states that although on the last occasion he submitted that he will be filing an affidavit, but he said he will be orally submitting the case. Prayer is allowed. List the matter on August 13. Okay.
Lordship,
This is-
August 13, I have a fixed matter.
then August 14, Thursday.
Lordship, I'll be going out of station, Lordship. I'll be coming back on that morning only.
Okay, after 2 weeks, as on a date to be fixed by the registry, but do it on the next date.
Lordship.
Don't keep it pending for so long. Yes.
Well, if I may be allowed to mention item number 22 for hearing.
This
for
is
the
also a
petitioner.
hearing matter.
Yes.
Hearing matters are listed and the councils do not do it.
I have some difficulties today. I have some fixed matters and the court one as well as before the Senate court.
22. Here also, I think the government was supposed to file reply to the additional affidavit.
No, Your Lordship, I have already placed it. I have
Will
placed
not
the
be.
instruction. Yes, I have already placed the instruction and this Honorable Court has accepted that, my Lord. And has listed it for hearing, my Lord.
It is already completed.
Yeah, pleadings already completed, my Lord.
Mr. So-and-so, appearing for the petitioner, has prayed for some time and have stated that the pleadings are complete. Mr. So-and-so, government advocate, states that he'll be addressing the court orally and would not file a reply to the additional affidavit.
No, Your Lordship,
Orally.
yes.
List the matter after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
Obliged. At least, Your Lordship.
Lordship, I beg to mention item number 21. Lordship, the principal counsel B.N. Sharma is not keeping well. And he-
21.
yes.
This is also hearing matter. This is an
Yes,
MSc appeal.
The principal counsel B.N. Sharma is not keeping well, Lordship. So if the matter can come out after 2 weeks. Counsel for the respondent.
You have taken consent from the other side. You are there for the petitioner. 22 matter again adjournment. So many adjournments. Hearing matters are listed for adjournments, I think. And then 21, right? Mr. So-and-so appearing for the respondent. Sole respondent? No. There are 3 respondents. You are for the claimants.
For the claimant,
And then you are appearing for all the 3.
Yes, for the claimants.
Okay. Respondents states that the leading counsel, Mr. B.N. Sharma, is not keeping well.
Yes.
And is not in a position to do the case today. The Mr. So-and-so appearing for the petition, appearing for the insurance company has no objection. List the matter after 2 weeks on a date to be fixed by the registrar.
Lordship, similar prayer for items 24 and 25.
Oh, these are also gone. These are all analogous matters or what? No,
No,
different matters, right? 24
But,
and 25,
yes.
gone.
Where
So-
for the respondents. Lordship.
Okay, 24 and 25, you write? Same, he is great. Same order will follow. You are there for the petitioner in 24, 25? Yes.
to the follow-up.
United Insurance and the Oriental Insurance. Okay. They are all subsidiary of the General Insurance, right? These companies are all subsidiary companies of the General Insurance. You are appearing for all.
No, I'm for 24. And she's for 24.
Oh, acha, 25 you write? This is National Insurance. Okay. And this is United India Insurance. That is the difference that will come. Okay.
Obliged, Lordship.
Lordship, similar prayer for item 7 as well, from the admissions list.
7.
Yes, for the respondent.
Here also B.N. Sharma appears.
Yes.
So Mr. So-and-so appear in item number 7 you write, Mr. So-and-so submits before this court that the leading counsel, Mr. B.N. Sharma, is not keeping well and is not in a position to do the case today. Mr. Yes, so-and-so for the insurance has no objection. You have no objection.
My lord.
Otherwise, this is admission. Has no objection. List the matter after 2 weeks.
The below, Lordship.
Lordship.
Yes, Lordship. Lordship, I beg to mention item number 3 on behalf of my senior Lordship, MD Sang Additional AG Lordship.
3.
Lordship, he's in bereavement Lordship, so if this matter can be listed after
Mr.
3
E.C.
weeks.
Sharma is there for item 3
Identity matter, it is a very small matter.
for additional evidence.
No,
Right?
additional ground,
Additional grounds.
yes.
But once it was sent to the trial court and it was the additional evidence was taken by the trial court and the report was given.
Yes.
Now again additional
No, Mother,
grounds.
the report, the findings of the district judge
Huh.
was against us.
Yes.
Therefore, we are to challenge that ground by adding one additional ground in our memorandum of appeal.
That you had added issue number
No,
10.
it is not added.
Acha. Issue
We
number
made a
10.
prayer. We made a prayer under Order 42, Rule 1. So, if your lordship granted the permission to file additional ground, then we will file.
No, what I could see from the IA is that the issue number 10 was framed by the High Court.
Yes.
And then additional evidence were under Order 41, Rule 27, I think.
No, no.
Additional evidence was directed to be taken by the trial court.
Trial court.
Then it was taken.
Then
and the
it was-
trial court has sent back the report
The findings of the trial court was sent back to the High Court.
on the additional evidence.
Issue number 10.
Okay.
Only issue number 10 goes against us. Therefore, we want to add one ground in our memorandum of appeal. And that for that purpose, a leave was necessary from the court under Order 42, Rule 1.
Okay, let the matter reach then. Now she is praying for
MD Sang Lordship.
some adjournments, huh?
Yes, Lordship.
One is in bereavement. Perhaps he has to say something.
Then tomorrow,
Bereavement, how can he come in within these days, right? When can he come?
Lordship, not this month, Lordship. So he was
I was instructed to list this matter next month, any date.
My lord, in that case, it may be fixed on the 25th of July.
25th won't be possible.
Your eye is for allowing the additional grounds to be
Yes,
taken,
yes.
right?
A very small point.
Would you like to file any objection to that IA? No instruction.
No instructions, Lordship.
You might like to
25th
file.
of August.
Okay. Miss So-and-so, appearing for the respondent, submits that the the government advocate,
Lordship. Additional AG.
additional AG,
Lordship.
that additional AG, Mr.
Interim song.
is in bereavement
Lordship.
and has prayed that a month's time may be given. Mr. A.C. Sharma appears for the applicant, and has no objection to the same. List the matter on 25th of August.
25th of August.
25th of August will be a month's time. 25th of August for hearing on the I. List this matter on the set date.
Highly praised.
Obliged, Lordship.
Pleasure, Lordship. Your Lordship, I beg to mention item 10 and 11 on behalf of my senior Pandang Wapang. Lordship, here, my senior Pandang Wapang, he, as a counsel for CBI, was till June only. And because of his non-extension, he submitted all his files to the office. However, it was only last week that the confirmation of his extension was released. So some time may be given to furnish back all the files.
He is not prepared with the matter. Last week only he was given.
Lordship, but non-confirmation of the extension, that's why.
But he was confirmed last week.
Only yesterday.
Oh,
That's
yesterday.
Yes, yeah.
Okay. Mr. So-and-so appearing on behalf of Bendang Wabang.
Lordship.
Bendang Wabang, who was appointed as an CBI counsel and was given extension only, and after his what do you say for that? He was not there.
Non-extension.
He was given extension to appear for the CBI matters only yesterday.
Yes, Lord.
As such, he has prayed for some time. The prayer is allowed. Mr. You are there for respondent.
Yes, yeah.
Mr. D.K. M.
M.
Solo.
M. Solo.
Mr. M. Solo appears for the sole respondent. Prayer is allowed. List the matter next week.
Lordship, if it can be fixed on 28th of August.
Fix on 28th, Your Honor.
28th of August.
Yes, Lord.
28th of August, just now.
List the matter on 28th of August. It's too long otherwise the date. It's okay.
Much larger.
For motion, item number 1.
May I please, Lordship? My Lord, this IA has been filed for extension of the interim. My Lord, there was an interim order dated 6/8/2024, staying the proceeding in CR case number 11 of 2024. However, on 14/7/2025,
Oh, acha, I was there.
yes, that
And the
means-
prayer was not made during the mentioning hours.
Yes.
When it was mentioned,
Yes.
and inadvertently
yes, so
it was not continued.
this IA is praying for extension of the interim order passed earlier.
Can the whole matter be taken up?
In this matter, I'm informed by my learned friend that he'll be filing the objection today.
Oh, acha.
So in that
You are
case,
for the? Oh, you will be filing objection to this IA?
no, not in the IA, but in the main petition.
Okay. You are for private respondent?
Yes, my Lord, I'm for the
Respondent number? 2. Okay. You are there for?
Yes, for the state.
What do you say on this? Of course, it was inadvertent. Yes, heard Mr. So-and-so for the applicant and Mr. So-and-so. This IA is filed for continuation of the interim order dated 6/8/2024, passed in criminal petition number 31 of 24. And 4. It was stated by the counsel that the matter was listed. The matter was listed on 14/7/2025. and it was mentioned, 14/7/2025, and a prayer was made on the said day for adjournment of the same. However, while making the prayer, inadvertently, the prayer for continuing the interim order was not prayed for. And as such, the interim order was not continued on 14/7/2025. The petitioner by this interlocutory application has prayed for continuation of the same, since it was inadvertently, inadvertently and out of mistake, the counsel did not mention about the interim order while praying for adjournment of the same. In the interest of justice, the interim order may be extended. An interim order dated 6/8/2024, passed in criminal petition number 31 of 24, may be extended till the next returnable date. Let him file the objection till the next returnable date. The IA is allowed. List the IA is allowed and disposed of. In the main criminal petition, you write, the Mr. So-and-so, appearing for respondent number 2, has prayed that he may be allowed some time to file the affidavit in opposition, right, to the criminal petition. The prayer is allowed. List the matter after 2 weeks. Ms. So-and-so appears for the state of matter.
My lord, if it can be on 12th of August.
12th of August. By that time, you file your affidavit. You file your affidavit next week. List the matter on 12th of August, as prayed for by the counsels.
Objection.
For motion, item number 2.
Ladies,
Yes.
this is a petition under 528 of the NSS, for quashing of the FIR and the consequential criminal proceeding.
FIR was lodged against how many accused persons?
Against 20 accused persons.
3 accused.
20.
Oh, 20.
20.
And you are for 6 persons now.
6 persons. May I take your ladyship to the FIR? FIR page 30. The relevant complaint, the written complaint is page 32.
Okay.
May I read it?
This is for quashing of FIR and subsequent proceedings.
Yes.
Charge sheet is submitted.
Charge sheet not yet submitted. Your ladyship may kindly appreciate that it has taken more than 2 years after filing this FIR. No charge sheet has been filed.
Oh, it is.
And the present petitioners, they have been harassed for quite some time. They have been summoned with no substance.
You have taken, they are on bail.
Yes.
All of them are on bail.
All of them are on bail, and there is also another accused person who is also on bail. So 7 out of 20 are on bail.
Okay.
May I read the FIR?
Yes.
This is addressed to the officer in charge, North Police Station, Kohima. Request for initiating necessary action against those persons involved in the sale of illegal tracked paper online lottery tickets in various parts of West Bengal. This is very important. In various parts of West Bengal, this jurisdiction is very important. Using the name and logo of the Nagaland State Lotteries.
Okay.
So that is the subject. Sir, with reference to the government letter number so-and-so, dated 1st of February 2023, on the subject cited above, I am state that the under-mentioned 4 persons at CL number 3 are reported to be indulging in the printing, circulating of fact lotteries in the state of West Bengal, tarnishing the image of the state. The government of Nagaland is organizing and conducting lotteries as per the Lotteries Act 1998 and Lotteries Rules 2010, as well as the rules of the Nagaland government and instructions issued by the Ministry of Home Affairs from time to time. The lotteries conducted by the state of Nagaland are in strict compliance with the provision of the Act and rules which are marketed in 5 states, where West Bengal is one of the biggest markets.
Who is
One,
the complainant here?
the director of lotteries department.
Acha.
Want to conduct smooth marketing of Nagaland state lotteries tickets in the state of West Bengal, government of Nagaland have appointed distributors. Inter alia, the distributors have appointed sub-distributors, and the sub-distributors have appointed area distributor, and the distributor thereafter have appointed stockist, sub-stockist, and retailers as. 2. Recently, several complaints have been received from the Nodal Officer Directorate of Nagaland State Lotteries, Camp Kolkata, and area distributor. So the complaint has been received from the Nodal Officer, Camp Kolkata. So the jurisdiction is falls under West Bengal. And area distributor, agent, stockist, sub-stockist, that some persons are indulging in circulation and selling of illegal paper lottery tickets, which flourish in various parts of West Bengal, resembling the name and logo of the state of Nagaland.
Okay, those complaints were filed in West Bengal.
Exactly,
Those are okay.
exactly.
But this is a complaint which is filed here. Then?
Yes. And your ladyship might kindly appreciate, there is also a similar case lodged before West Bengal.
Yeah, that
Kolkata.
seems so. Yes.
And now the charge sheet has filed,
Acha.
and the present petitioners before the Honorable Court, they are being discharged from the criminal liabilities.
Okay.
Similar offense.
Discharged?
Similar, yes.
In
discharged.
framing of charge stage.
Yes. I'll also come to that, your ladyship. 3. From the complaints received by this office from the various stated stockists, sub-stockists in the state of West Bengal, we have come across some common names who are involved in the printing and circulating fake lotteries in the state of West Bengal. A is the present petitioner number 1, B is the petitioner number 2, C is a co-accused.
Who is not a petitioner.
He is not a petitioner, but he is also on bail, and D is petitioner number 4. You'll also, your ladyship will also find the other petitioners as we proceed towards the FIR. Detailed list of the person and activities involved in is also annexed here with for your ready reference. So all the 20 persons are enlisted in a separate annexure. 4. These people are also trying to malign the repetition of the Nagaland lotteries by duplicating, using the name and logo of the state lotteries in the fake. So the allegation is mainly using the fake lotteries and using the logo of the state of Nagaland. That is the allegation. Now, if I may be allowed to refer to the paragraph 6.
What about 5? Pawan Jhunjhunwala is also involved.
Yes, Lordship. 5 is also one of the accused. Pawan Jhunjhunwala.
He is not a petitioner here.
He is not a petitioner, but he is one of the co-accused persons who is also on bail. Is involved in printing and circulating lottery tickets in the state of Jharkhand and Bihar and various states as registered in list regard in the name of different police stations. So that is the allegation pertaining to the co-accused, Mr. Pawan. 6. Atul is the petitioner number 1. Also regularly files RTO applications to the department and tries to get confidential documents from the department. Has also filed a complaint before the ED. To malign the image of the state's lotteries, Nagaland state lotteries.
Why is he trying to get the confidential documents from department? And had also filed before ED.
Yes, Lordship.
To malign the. Acha. Okay.
What has happened, Lordship? All these informations are obtained. All the petitioners, they are members of lotteries association in the country. Now they have been trying to get information as to the practices of the lotteries in the state as well as the other 5 states. Now what has happened? They have come across some activities which are illegal in the IF law. Now they have lodged complaint before many authorities, including the Prime Minister of the country, as well as the Chief Justice of India, and others authorities, bringing on record the malpractices that has been, going through for so many years. In fact, we have also made an allegation against Mr. S. Martin, who is the kingpin of the illegal state lotteries in the country. Specific allegations are made against him. Now, what has happened, if your Lordship may kindly appreciate, we are. It is my respectful submission before this court is the whistleblowers who tried to expose the malpractices in the country, whereas we are being tracked in this case. My respectful submission is we are innocent people. We try to protect the society. We try to expose the corruption, malpractices.
But you were only made the accused here.
Exactly, that is the case.
Okay, go on. Then, maligned the image of Nagaland State Lotteries and has
Yes,
attached.
and has attached the agreement copies between the government of Nagaland and the distributors, which is confidential, is not even shared to Mr. So-and-so, even after his repeated RT applications. There's a reason, Your Ladyship, there's a reason why informations are not being provided. Your Ladyship, well aware, any citizen of the country under the RTI Act can obtain information, but those are being denied by the state government to the knowledge best known to them. Further, in the same complaint to the ED, the state so-and-so has attached a confidential letter so-and-so, which was issued by the MHA to Nagaland government, which has never been disclosed in public document.
But it was given to him. You said it was not given,
Yes,
but
yes.
then one letter is given.
Yes. After
Then-
several attempts were made, finally those documents were made available to me. After that, I have to written a complaint to those authorities which I have mentioned. He is maligning the image and reputation of the state lotteries and has procured the documents by illegal means. So this is the allegation. And is purposely sharing the same in open market. The wrongful act of this person are also published in newspapers and news portals, which are also enclosed here with for kind perusal. And their FIR is already registered against him in the state of West Bengal. They have already stated that their FIR is lodged. 7. Further, the accused have above named persons are also engaged in producing, manufacturing, prize-winning lottery tickets after telling the same from the result published by the Nagaland State Lotteries. This persons then release such fake prize-winning lotteries into the market and engage them with the retailers, and ultimately the retailers of lottery tickets get duped by their activists. Further, the state of West Bengal, so-and-so, this is about the allegations made in the FIR in the state of West Bengal. 9. Further, it is learned from different sources that the above named persons are further involved in conducting, organizing illegal online lotteries by various names and most illegally run the same in the state of West Bengal, being fully aware of the fact that by so-and-so of Kolkata Gazette notification so-and-so, the state of West Bengal has banned the sale, marketing of online lottery tickets in the state of West Bengal. In the light of the aforesaid circumstances, we hereby request your good office to kindly take necessary actions against the perpetrators for the offences of 1. Dealing and selling of illegal paper lotteries in various parts of West Bengal. So it is all in the state of West Bengal, not in the state of Nagaland. Cheating public by illegally conducting online lottery draws using the personal computer machines not connected to central server. C. Misuse of Nagaland state logo and theft of important official documents pertaining to state lotteries which were furnished to Atul so-and-so in the RTI replies. And instantaneous action will protect the innocent common citizens from fraud and also save the numerous honest persons who are associated with the legal paper lottery business and are doing business sincerely to earn a livelihood to support their families. It is therefore requested to take stern action against the offenders by initiating appropriate legal proceedings, including the registration of an FIR and prosecute them for the commission of various offences as required under the law against the culprits so that such instances should not happen in the near future.
Not a case for interim. See the allegations here. Although you have said that this has all happened in West Bengal, about the jurisdiction and all.
Yes.
Secondly, he was in fact fighting for the illegal things that has been happening in the lottery system.
Yes.
But then see, he has used the logos and everything. He has issued fake lotteries, duping people.
That is mere an allegation before the authorities.
And the investigation is on.
Yes.
Charge sheet is yet to come. Looking at the allegations, they are serious, of course, subject to what is being found by the police. But
This Honorable Court may kindly appreciate that it has taken more than 2 years to complete the investigation.
no, because it is, so many things are involved, so many people, different states. So they are taking time,
Off the report, if I may be allowed to make a submission. It is on the direction of the CM of the state of Nagaland that it has been kept on hold. No further investigation.
That is, of course, again
off the record,
speculation
off the
that
record, with
you
due
cannot
respect.
say. But
With due respect.
what do you say on this?
No,
Oh, he has not finished.
if I'm being allowed to refer to the charge sheet which has been filed in the state of West Bengal, just one or
may
two
not be
properties.
relevant. lady.
Yes,
Yes.
we
one or
will
two
go by
properties.
this
Because-
FIR
because
only.
It's the same charges, the same
FIR.
charges.
Yes, you said that same charges, charge sheet was submitted thereafter they were discharged.
Just one. The clause 11A,
Page?
103.
Yes.
The rest I'll leave it to the wisdom of the board. 11A, 11A.
11A,
Same
yes.
page, yes, 11A.
Yeah,
Name of accused person charged sheet at 5. So these are the 5 accused persons. Your lordship will find at the bottom of the page. These are the 5, the present petitioners are not included. Now the 11B is also important, this is relevant. Name of accused person not charged sheet at 8 of them. So 8 includes the 6 petitioners before this honorable court.
Not
Five-
charge sheeted. So petitioner was not charge sheeted.
Not charges. not
Achha, they were
charge-sheeted.
discharged by the police only.
Exactly.
I thought they were discharged by court while
Only by
framing
the
of
police,
charge.
put it by the police. After conducting investigation, on completion of investigation, report filed under 173.
Yes,
No, only
but-
5
yes,
persons they were.
Although you are saying the case is same and all, but then here we have this particular FIR.
I
Right.
have an interior period.
What do you say?
No interim at this stage. It will derail the process of justice and frustrate a fear in investigation. There is a prima facie case of cognizable offence.
See, quashing of FIR, we will see whether cognizable or case has been made out or not.
Yes. It has
Here-
been record from the FIR.
Yes, here your charges are under what? 417? What are the charges?
464, 465 and 499.
So cheating is, see, duping of people are there.
Conspiracy is also there.
And
120.
online is also banned,
Yes.
but then online is being, this is what the FIR says. May not be correct, I don't
If this
know.
honorable court may kindly appreciate, I have appeared before the investigating agency as and when required, 2-3 occasions. I have appeared. And it has also been reflected in the order when the bail was granted. Bail was granted on 29/4/2020.
No, but
There
in
is
this,
no precedent
but
of
stay of
interim.
investigation, you
Yes.
know. What I can make out is that you read. You know that stay of investigation is not allowed by Supreme Court unless
Yes.
exceptional case.
So this is also one of the
What
exceptions.
exceptional?
no.
See the charges. Here they were
This
what?
honorable court may kindly appreciate
Yes,
that I have
printing-
been cooperating with the agency.
No, that is
Printing
okay.
of fake
But,
lottery, all
Ready to
this-
cooperate.
but staying of investigation
Yes.
unless it is an exceptional case is not made
2
out,
years,
I
2
can.
years. That shows that my presence is not required, interrogation. Because I have appeared
No,
before.
you were already
Enjoying the
interrogated
protection.
statement.
Yes.
And this is
You are
only
on bail.
pertaining to only the present petitioners who are before the third court. It is not an interim prayer for all the accused persons, only pertaining to the 6 persons.
6. But then see, at least 2 of them are named here, 3 of them, 1, 2 and 4. What about the others?
Their names also there. There's a list.
Oh
enclosed in
yes,
the
there is a
FIR.
list there, no?
Yes.
Where is the list?
Page number 34.
See,
34.
list of persons in fake lottery.
Yeah. Altogether 20
See,
of them.
what I can see is state of Nagaland has been doing things very nicely, what it appears to be, by following the rules and the act.
Records will speak.
Yes, and they have appointed all those distributors, everything. And then they are doing this online and fake by using logo. They have also taken out documents which were confidential. And then, so let the investigation continue.
Yes.
Then the investigation, Chasha, case diary also whether it is required. I don't think so. Okay, let the case diary be called for,
notice
up to
be
date,
Yes.
and notice to ND so and so. This is an application filed under section 528 of the BNSS 2023. Read with article 227, that was not required. Read with article 227 of the Constitution of India for quashing of the FIR and the consequential criminal proceedings initiated against the petitioners in connection with Kohima North Police Station case number 9 of 23. dated 13/3/23, registered under section 120B/417/464. What was 464?
Forgery.
Forgery, yeah. 464 slash 465 slash 499 of the IPC. The ingredients of forgery, where are those? Forgery, cheating is there, but forgery,
They have to establish that I have manufactured the document.
not the case diary come with the
Yes,
exam, of the IPC. What subsequent charges in the
Yes, there are subsequent charges. It's in the cost title.
charges were also framed? Oh, why? Charge sheet is not there?
Subsequently, these are
Added?
incorporated, yes.
Oh. Or registered under so and so. With further addition of charges, under section 34. 34 is common intention.
Yes.
Slash 420 slash 500. So many charges. Slash 467 slash 468 of the IPC. Read with Lotteries Regulation Act 1998. The case of the petitioners, as is reflected from the FIR dated 9/3/2023, is that the petitioners were reported to be indulging in printing, circulating of fake lotteries in the state of West Bengal. A lot. Further, there has been many complaints from the nodal officer, Directorate of Nagaland, that the petitioners further, don't write that line. Cut it. What did I say? They were found. They were found indulging in so and so, right? And there are allegations. There are allegations also that they were indulging in circulation and selling of illegal fake lottery tickets resembling the name, logo of the Nagaland state lotteries. It is also alleged that the petitioner number 1 had filed RTI applications to get confidential documents from the department and had filed certain complaints before the ED to malign the image of Nagaland state lotteries, which were otherwise conducted by following all the rules and regulations framed by the state of Nagaland. The petitioners were also found engaged in producing, manufacturing fake prize-winning lottery tickets after tallying the same from the results published by the Nagaland state lotteries. It is also alleged that the petitioners releases the said fake prize-winning lottery tickets into the market and encash them with the retailers which ultimately cheats the ultimate retailers of the lottery tickets. Issue notice to the issue notice respondent is only state of Nagaland. Now Miss so and so appears for the respondent. Since Miss so and so appears, no formal notice is required to be served upon her. However, extra copy is not required.
Not required. My
Not
copy will suffice.
Okay. For so and so. The matter is to be listed after 2 weeks. The interim to be considered. Oh, the case diary. The up-to-date case diary is called for. The interim to be considered on perusal of the case diary. If the case diary reveals something different, then of course the interim. Otherwise, on the face of this FIR, difficult. Okay.
Obliged.
For motion, item number 2. I beg your pardon, for motion, item number 4.
I think there is an impleading application here.
Your Lordship, my senior is on another court. So
After some time.
yes. Item number 4 and 5.
Item number 4 and 5. 4 is otherwise for impleading. I think this is the new incumbent.
Yes, Your Lordship.
Let your senior come.
Yes, Your Lordship.
Okay, after some time.
For motion from the supplementary cause list, item number 26.
Please, my lord. Lordship, this is
On the other day, you appeared for that scale pay matter, right?
Yes, yes.
I have delivered the judgment. It will be online. Okay.
My lord, my lord, my lord. I'm obliged.
Yes. Then
This is a POCSO case. If the online,
this is bail.
yes,
Oh, this is bail. POCSO matter.
yes. If
Let the
the,
victim come
my lord, my lord,
because every stage victim needs to be heard.
my lord, my lord.
Okay. This is the first time listed.
Yes,
Okay. So this is a bail application under section 480 of the BNSS, filed under section 480 of the BNSS, praying for release of the petitioner on bail in connection with Women Police Station Kohima case number 0006 of 25 under section 64 subsection 2 clause Roman 1 BNS, read with section 4 of the POCSO Act. As it is mandatory that a victim has to be heard in every stage of a case involving her, issue notice to respondent number 2, or she is not.
she is not impleaded.
Oh, not.
The PP can.
No,
It will
you
be
have to
difficult without
implead.
implement.
All right, then
No
in that
order
case,
can
I
be
may be
passed.
given the liberty to withdraw this with liberty to file afresh.
Okay.
I'll implead the respondent, the victim as respondent number 2 here.
Since I have dictated, there you write, Mr. Since it is mandatory every stage, the counsel for the petitioner has inadvertently missed out in impleading the victim as respondent number 2. As such, the counsel makes a prayer that he may be allowed to withdraw and file a fresh bail application. The prayer is allowed. the petition is disposed of as withdrawn.
My lord, my lord.
With a liberty to file a fresh.
My lord, my lord. The victim is now a major, so the implement
Doesn't
of
matter.
cartoon, yes.
Doesn't matter. She was
Yes.
there.
Yes,
then-
yes. Implement of cartoon may not be necessary. That's
Okay, you implead the victim only, not
lord, my lord.
complainant is otherwise who? Father, mother,
no, the victim herself.
or victim herself.
Yes,
Okay,
yes.
implead her.
My lord, my lord. Much obliged.
For admission, item number 8.
8. Mr. Das, you are there.
Yes, ma'am. We need some time because a rejoinder has to be filed in this case.
Acha, Bapre, this is a big one.
Yes, that's why.
Or rejoinder was not filed.
Not filed. But
Lord,
we'll take up item number 12, my lord.
Lord, 12 is the one where I had filed a application seeking clarification. If my lord will only have.
This is item number 12, not item number 8.
12.
Your lordship will take any other date, my lord, but your
8.
lordship will take item number 12.
8, you'll file your rejoinder.
Yes, rejoinder.
8, my lord, can defer it because they need some time for rejoinder. I have no problem.
Okay. As far as 8, let me pass the order. In item 8, Mr. D. Das.
Clarification.
Clarification will come in item number 12.
No. In item 8, I have one only request. It appears by inadvertence, my lord. In the item 8, it says interim order, if any, to continue. In item 8, there is no interim order.
Acha, it was
In item 8, there is no
made to continue.
Yes, so in item 8, there that line, I think, by mistake has crept in the last order.
Doesn't matter, we can hear the entire case. Instead of going for clarification.
No, I am only saying. No,
You are
I am not on.
There is,
For item.
there is something wrong with the internet. You are not audible in between, in parts,
Oh, I see.
your voice is coming.
I see, my lord. I am just logging in quickly. I'll log in from the other device, my lord.
In item number 8, I'll give time to Mr. Das to file his rejoinder affidavit.
My lord, inadvertently, it is interim order to be heard on the next date, to be considered on the next date.
Then what
That
happened?
was, I think something was there. What is that order? To be
Interim order
continued.
passed earlier shall continue
There
till
is
the-
no interim order in this case.
Oh, acha, this was wrongly.
Inadvertently, that's why it will be
But I was
considered.
trying to clarify.
Now what to do with this order? Let it remain, let the entire matter be heard.
This is your lordship will fix it on some other date, this matter.
Yes.
8.
No, as far as this order, which
Yes.
crept inadvertently.
Yes. Because we never prayed for an interim order in this case. Because my learned friend was also there on that date. And we only said that let this matter come up and interim order will be taken up on the next date for consideration. That what we
Okay, I'll
prayed
reflect
for.
that in the order
Yes.
that it was
Please, your lordship will reflect it in the
invalid.
order.
Mr. T. Das, assisted by learned senior advocate, assisted by as does for the petitioner. And there was no one. ED is there, no?
Yes.
Mr. Hussain.
Item 8, my lord, I am there
You are there for the sole Directorate of Enforcement. YP
for the
Gupta.
Directorate of Enforcement.
You are otherwise Mr. Hussain, right?
That's right. I'm the special counsel, my lord.
Mr. Hussain for the respondent.
Lordship, I am also appearing on behalf of ED, Your Lordship. SPP Ankit Khanna, Your Lordship.
Assisted by YP Gupta.
Ankit Khanna, Your Lordship.
YP Gupta and Ankit Khanna.
Achha, okay.
YP Gupta and Ankit Khanna.
And YP Gupta and Ankit Khanna for ED.
Login for this.
It is placed before this court that in the instant case there was no interim order and in the previous orders there were only directions for the interim order to be considered on the next date. However, on 16/6/2025, inadvertently, it was reflected that interim order passed earlier shall continue. Since the same was reflected mistakenly, the same may be ignored. for the ends of justice. Mr. D does praise that he may be given some time to file rejoinder. Rejoinder to the
To our count
affidavit in reply.
objection. To our reply.
Rejoinder to the affidavit in reply.
Yes.
And has prayed for 2 weeks' time to file the same. List the matter after 2 weeks? After 2 weeks?
Yes, it may be listed on 11th of August.
Okay.
11th.
List this matter on 11th of August, as prayed for by the parties.
Only that day interim order will be considered.
Yes. Again, same thing. We'll continue.
That's right.
The interim order to be considered on the next date.
I am deeply aware.
Very good.
Lordship can take up if it is not inconvenient.
Yes.
On to item number 12, my lord.
Acha. What about 9, 10?
9, 10 is not our matter.
Well, those were not connected to this.
Acha, those
Item
were
12.
not. Oh, okay. Those were 12.
Item 12 is
For item
connected.
number
Please
12.
see the
The
last order,
objection
Manu.
has come. Has come. Your objection has
Yes.
come.
Yes.
Already we served the copy on Friday.
In fact, Lord, this,
Somehow we could not file it.
in fact, if I may only point out, my lord, this matter may not require any further adjudication in light of my learned friend's objection. Please see the last order as to what was the controversy. We were only seeking a clarification, Lord.
I'm yet to see the objection.
Yes.
Otherwise, on the last occasion,
I'll
I've
only
seen
show one.
that you
My lord,
wanted some clarification on few others
That-
and to bring into record subsequent events. Right.
Correct. Now, please see that order, my lord, 14 July.
Acha.
For admission, item number 12.
My lord has the 14 July order.
No, I'm yet to get the file with.
Oh, I'm sorry, my lord. I'm
It's
sorry.
okay. You want me to take up the IA?
Yes, my lord. I just want to place the order which your ladyship had passed, and then I will place my IA.
Yes, I remember my order. It's okay.
Yes, my lord. So, my lord, two reasons why we were seeking clarification, because the main petition was concerned with a challenge to NBW issued by a court on an application filed by ED because of his non-cooperation. However, my lord, one order came to be passed by this honorable court directing no coercive action, and subsequently the NBW was stayed. Thereafter, orders were passed saying earlier interim orders to continue. My submission was twofold: that the section 19 power was neither under challenge in the main petition, nor could the court ever comprehend passing an order regarding the 19 power, because that was not even the subject matter of a final relief. Interim relief is always in aid of final relief, and no interim relief was also sought regarding stay on arrest or no coercive or anticipatory bail kind of a relief. Now, in that context, just to cut short the time of the proceeding, please see my learned friend's objection. He agrees with me. And it's a very fair response of my learned friend, and therefore, by recording his agreement, the matter, our IA can be disposed of. Please see that, my lord.
Yes. Which paragraph you wanted me to see?
Yes, para 12, my lord, may see.
12 of the objection.
12 of the objection. Objection filed to my IA, my lord.
Yes.
The
Arrested
deponent
is on
submits. I'm sorry.
bail. Yes. The arrest and bail release.
My lord,
on
may I
bail.
read, my lord?
Yes.
The deponent submits that the arrest and release on bail of Bhupesh Arora in connection with Cybercrime Police Station FIR has no connection with the instant case warranting an urgent hearing. Further, the orders passed in the instant revision petition by this honorable court was not passed in light of section 19 of PMLA. 19 is the power of arrest, my lord. The said orders were passed in respect of an order dated 13th December 2024 passed by the learned trial court, whereby the NBW issued earlier with a order dated 2nd July was directed to be executed. The said provision for issuance of an NBW by the learned trial court is provided under 75 of BNSS, and as such has no connection with section 19 of PML. Therefore, the same does not warrant any clarification. So my submission was exactly the same, that the interim orders passed. My lord, am I audible, my lord? There was some break in the.
In between, you are not.
Therefore, my submission was, my lord. I'll join from the other. My lord,
Mr.
can hear me clearly now, my lord? I just changed my device, my lord. Therefore, my lord, my submission is reflected in my learned friend's objection, where he agrees that the scope of the petition that he filed related to the NBW, which is a power under section 70 and 73 of CRPC and 75 of BNSS, and has nothing to do with the section 19 power. The only reason we fairly came before this honorable court, my lord, seeking this clarification is because of one no coercive order, and we did not, as an agency, my lord, we did not want to appear as if we are overreaching the court order in any manner. And my learned friend's response now, my lord, is we are both ad idem that the interim orders passed in these proceedings was not in the context of our power under section 19. So by recording this para, my lord, the clarification application may be disposed of by recording that both parties are ad idem, that the interim orders only restricted to the NBW orders, my lord. So that's the only submission, my lord. And unless my learned friend is disputing what is written in the affidavit, then I will have to make further submissions.
But one thing, like, because there is already an order for no coercive. Now, if you
Yes.
want to bring that accused person from Haryana, I think, then you'll have to bring it by transit order and all, by making an application before the
Yes.
Haryana court. Right.
Now,
So that will be
thereafter, my lord,
that will be
thereafter,
perhaps taking an action against the petitioner.
yes. Therefore, my lord, I will address the argument, my lord. My first submission in that regard is please see the prayer sought in this petition, my lord. The no coercive action order was only with regard to execution of the NBW. Number one, please see the prayer.
But whether that can be the interpretation.
I will assist.
Where is no coercive action?
Yes, please see the prayer in the main petition first, my lord. An order which is never intended cannot be construed in a manner which restricts the power, independent power under section 19. Please see the main prayer at page 24, my lord has it, in the main petition.
24.
Yes, of the main petition, my lord. That is criminal revision 3.
Criminal.
Now,
Criminal.
the criminal revision, my lord, not the criminal appeal. Criminal revision.
Page.
Page 24, my lord, may I have.
Yes. Admit the petition and so and so. Quash the
That's right.
order 1312.
That's right. Quash the impugned order dated 13/12/2024. So, and then restore the interim order dated 5th September 2024, extended by the order dated 18th October 2024. Till the pendency of IA. Stay the operation of the impugned order dated 13/12/2024. Stay the execution of warrant of arrest. Now, my lord, it is well settled. There are two kinds of arrest. One, which is pursuant to the NBW orders of a court where a person is arrested, and the other, which is an executive action under the respective provisions of section 19 or any other law of the land. Now, please see, my lord, the original prayer, the final relief was only with regard to the NBW order by way of which the person who is absconding was directed to be brought to court. Please have that order, my lord. The impugned order is at page 29.
1312 order. Yes.
Yes, my lord. That is at page 29. Now, if my lord will have the page over, page 33 is the operative part. Learned PP prays for issuance of warrant of arrest to be executed through SP of each district as per the address of the accused. Prayer allowed. So an open-ended warrant and its execution was permitted.
This
Now
is
this,
bailable. This is bailable warrant of arrest.
no,
Right?
my lord. No, my lord. This one is bailable warrant of arrest. Please see, my lord.
Acha, page 29, this is non-bailable warrant of arrest.
That's right. That's right. That's right, my lord. Now, please see, my lord, the interim orders that have been passed from time to time was only with respect to the
This order.
power with this order, and it could never have been with respect to any other order. Now, if I may request, my lord, to have a short compilation, my lord, that I had handed over last time, which
Yes,
starts with the judgment of Ajay Singh, my lord.
Yes, that you have shown last time.
Yes, so there are two kinds of arrest.
Yes.
Please see section 19 of PMLA. Section 19 of PMLA, if we have to arrest a person, we do not require any permission of the court. That is an independent power as against the exercise of power pursuant to an order of NBW. 5-judge bench of the Supreme Court. Please have Ajay Singh, my lord.
PMLA Act, Mr. Court Master. PMLA Act. If you... Yes, which page?
Page 13, para 20 of the compilation, my lord. Broadly speaking, arrests may be classified into two categories, namely arrests under warrants issued by a court and arrests otherwise than under such warrants. As to the first category of arrest, section 75 to 86, collected under subheading B, warrant of arrest in chapter 6 of CRPC, deals with arrests in execution of warrants issued by a court under that code. That is the first kind of arrest that my lord was concerned with, pursuant to execution of NBW. Section 75 prescribes that such a warrant must be in writing, signed by the presiding officer, and bear the seal of the court. Form 2 of Schedule 5 to the code is a form of warrant for the arrest of an accused person. The warrant quite clearly has to state that the person to be arrested stands charged with a certain offense. Form 7 of that schedule is to bring up a witness. The warrant itself recites that the court issuing it has good and sufficient reason to believe that the witness will not attend as a witness unless compelled to do so. The point to be noted is that in either case, warrant expressly sets out the reasons for arrest, namely the person to be arrested has committed or is suspected to have committed or is likely to commit some offense. After noting this, please see para 21. Apart from the Code of Criminal Procedure, there are other statutes which provide for arrest in execution of a warrant of arrest issued by a court. To take one example, Order 38, Rule 1. So the court is giving, my lord, multiple examples of what are the two kinds of arrest. One is pursuant to court order. It could be under the CPC as well. And the other is pursuant to the executive making the order. Now please turn to, my lord, para 24. Turning now to Articles 22(1) and 22, we have to ascertain whether its protection extends to both categories of arrest mentioned above. And if not, then which one of them comes within its protection? There can be no manner of doubt that arrests without warrants issued by a court call for greater protection. That is, my lord, if ED was to arrest under 19, that calls for greater protection than to arrest under such warrants. I'll say why, my lord. Because when a warrant is issued by a court, we can't, while executing the warrant, take him into our interrogation room, take his custody without the permission of the court. The moment we execute the warrant, we have to produce that person along with the warrant before the court. We can't take him in our custody and start questioning him. But when it comes to a Section 19 arrest, that is the second kind of arrest that the court asks for, we get 24 hours to question him. If our investigation is not complete within 24 hours, we produce him and seek his extension. So we seek his remand, where the magistrate will have the power to authorize his further detention. the detention can last up to 14 days. So the two procedures are different. So therefore, my submission is the subject matter of the present petition in which the interim order came to be passed had nothing to do with the section 19 power of arrest. So therefore, the no coercive action order, even if it is to be read to continue to subsist, is only in respect of the open-ended NBW issued by the trial court and not impinging upon section 19 arrest, number one. Number two, that very no coercive action order, in my humble submission, stood modified by the subsequent order. Please have that modified order, my lord. That, my lord, will find 21st March 2025. The earlier no coercive action order, my lord, that my lord has seen, that was a order without any reasoning, because I believe, my lord, the court wanted to hear the matter and pass reasoned order. 7th March 2025, my lord may see, is the no
Next
coercive
month.
order. 7th March, where there is no reasoning, my lord. Time sought for counter till the next date, no coercive steps to be taken.
This is in respect of Criminal Revision 3.
Same petition, Criminal Revision 3.
Yes.
In which the final relief is only regarding the NBW. Then on the 21st March, the court hears the matter at length. And please see para 4, my lord. He
Paragraph 4.
submits para 4. The petitioner's submission is recorded. It is important, my lord, because petitioner's understanding throughout, right up to the filing of the present objection, has been consistent. He is not saying that the interim orders are in respect of your power under 19. He is also saying that the interim orders are in respect of the NBW issued. Please see para 4, my lord. He submits that in the instant revision petition, the petitioner has impugned the order dated 13 December 2024, passed in ML number 1 of 24 by the Special Judge Dimapur, Nagaland, whereby non-bailable warrant of arrest was issued against the petitioner. The learned senior counsel has submitted that the main ground for issuance of non-bailable warrant of arrest against the present petitioner was that the petitioner failed to appear in person before the court in pursuance of the order dated 5th September 2024. Learned senior counsel for petitioner has submitted before registration of ISO and so, the learned trial court had on an application made by SPP in ISO and so issued non-bailable warrant of arrest without giving an opportunity to the learned counsel for the petitioner to be heard. The learned counsel also submitted that after submission of charge sheet, summons were issued to 299 accused. Then that is not relevant, my lord. Must straight away come to para 11, where the findings start. Considering the submissions made by the learned SP senior counsel for petitioner, the learned SPP has submitted that since ED has sought time for filing of written objection against the revision, he has no objection to grant of interim relief sought for by the petitioner. In this case, till next date, considering the submissions made by the learned senior counsel for the petitioner prima facie, it appears that the order dated 5th September has not been violated by the petitioner. Hence, till next date, the operation of the impugned order dated 13 December shall remain stayed, and the non-bailable warrant of arrest issued pursuant to the impugned order shall also remain stayed till the next date. Therefore, my humble submission is, first submission, my lord, the no coercive action order was modified by this detailed reasoned interim order, and this detailed reasoned interim order only state the execution of the NBW, which is distinct and different from the power of arrest under section 19, for which the ED needs no prior permission of the court, because ED, my lord, or any other investigating agency in its investigative role does not require prior permission, my lord, for arrest or summoning or interrogation. Thereafter, my lord, may please see the next submission. Please have, my lord, page 20.
Page 20 of the main petition.
Of my compilation, my lord, of my compilation. The principle is, my lord, that a relief which has not been prayed for could never have been granted. So my learned friend did not pray for stay on Section 19 power or an anticipatory bail under 438 or any kind of prayer for no coercive action pursuant to Section 19. Please have Bharat Amritlal Kothari. Even in exercise of writ powers, the Supreme Court says High Court should not and cannot grant a relief not prayed for. Please have page 20, my lord. Para 29. At relevant at page 30. This is a Supreme Court judgment, my lord, passed by the Honorable the Division Bench of Justice Bedi and Panchal, page 30, para 29. The approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 must contain a relief clause. Whenever the petitioner is entitled to or claiming more than one relief, he must pray for all the reliefs. He has not, my lord, may no, only note, he has not prayed for any relief in relation to Section 19. And he admits that in his objection.
There was no occasion. There was no occasion.
There may be no occasion, therefore the court never intended to grant him a relief. My lord is right, there was no occasion. Therefore, since there was no occasion, the interim orders does not in any manner interdict the ED in exercise of its power under 19. We just want to ensure that, my lord, we are not in any way even perceived to be...
This even Mr. Das has said that this will not
That's right.
include
That's
Section 19. But
That's right.
what he says further.
Yes.
Yes. And then?
Now, please see, my lord, the next proposition is in this very compilation, if my lord will see, an interim relief can only be in aid of a final relief. My lord may only see the index of the compilation that I've handed over. I'll not trouble. That's a very well settled proposition, so I'm not troubling, my lord. An interim relief can only be in aid of or a supplement to the final relief.
No,
Therefore, in the final relief, when he does not seek Section 19 stay or an anticipatory bail, this does not in any manner prevent us from proceeding because the no coercive subsequently converted into a stay on NBW does not create any embargo on Section 19 power, my lord. Then, my lord, may one more submission, my lord, may note. Even assuming, my lord, my learned friend had sought any kind of interim bail, interim anticipatory bail, even assuming, my lord, my learned friend had sought that, that would have to be done in terms of the three-judge bench judgment of Vijay Madan Lal. Please see page 41. Page 41, my lord will see, is the three-judge bench of Vijay Madan Lal Chaudhary by the Honorable Supreme Court, where the entire vires of PMLA was under challenge. And my lord may straight away come to para 412, where the vires of section 45 of PMLA was also under challenge. While upholding the vires of 45, the court makes a very, very important observation which will be directly applicable here. As a result, we have no hesitation in observing that in whatever form the relief is couched, my lord may only mark this expression, in whatever form the relief is couched, including the nature of proceedings, be it under 438, that is the anticipatory bail, or for that matter, by invoking the jurisdiction of the Constitutional Court, that is my lord's jurisdiction, the underlying principles and rigors of section 45 must come into play and without exception ought to be reckoned to uphold the objectives of the 2002 Act, which is a special legislation provided for stringent regulatory measures for combating the menace of money laundering. And this is a classic case of that nature, my lord. Large number of investors duped, monies promised to be doubled, taken away and possibly out of the country, angle of Chinese elements present, person becomes a fugitive economic offender order challenged before this honorable court, and finally, despite lookout circulars being in existence, they don't get triggered in the airports. He comes back through the illegal and illicit route. He is arrested by the Haryana police. we go and record a section 50 statement. We are given 2 days permission by the Faridabad court. We are able to record him on one day. The other day, he's picked up by Delhi police. He is sent to Tihar on a production warrant. Thereafter, my lord, he gets a bail in the Haryana case because the complainant is won over and he settles it. Thereafter, ED in a Hyderabad case arrests him and then seeks his warrant production, and he is now in judicial custody in the other ED case, which is a Hyderabad fraud, my lord. This is the checkered criminal antecedent that this person has, and therefore that's yet another reason, my lord, where this clarification and even the instant petition, when my lord takes it up finally, the petition would have to be rejected. I will place those facts because of the conduct, the antecedents, and the background of the case, and more than 903 crores of proceed of crime, 2,200 crore of proceed of crime siphoned off of innocent by persons who have given their entire life savings with the hope that their money will get doubled. Now, in that context, my lord, para 412, when the no coercive was granted, court never intended to grant interim bail. Why? It is presumed that the court knows the entire law. The court is aware of the entire legal framework, my lord. Para 412 of Madanlal says, if you were to grant any kind of interim bail, in whatever form the relief is couched, my lord may see, my lord has just marked that expression. My lord has that?
Yes.
In whatever form the relief is couched, including 438 or by invoking the jurisdiction of the Constitutional Court, the rigors of 45 must come into play. Now, please see 45 of PMLA. There is an embargo by the legislation that no court can grant bail unless it gives a finding that reasonable grounds to believe that he is not guilty.
Like in the NDPS cases and all.
Exactly in the NDPS case. Like.
These are there, but now we are with the only IA, with your
only IA.
With your limited reliefs. Now what I can make out from your submission is that Section 19, there is no embargo, even if those stay and those coercive measures are there. You can still arrest him under Section 19 of the Act. But then you have just said that you have already recorded his statement.
No, we took permission for 2 days. We were able to record for only 1 day. We need his custody. All that, my lord, we don't. Today, this honorable court, my lord, is not considering my remand application pursuant to arrest. I have to satisfy that to the special court when I file my remand application as to why custodial interrogation is required. That is not the subject matter of the proceeding pending today before this honorable court. If my lord wants me to satisfy why we need his custodial interrogation, we can do that.
Not required. We will limit ourselves to.
That's right. That I have to justify and satisfy, my lord, a different court when my arrest is being examined. Is your arrest in accordance with, because my lord, Supreme Court lays down very stringent requirements of arrest now. Section 19, you have to supply grounds of arrest, you have to supply reason to believe, you have to follow Article 22, DK Basu. So you have to do any recording in videography pursuant to Paramveer Singh Saini. So host of safeguards, my lord, for the accused is now catalogued. So we will satisfy that all of that when we take that action, when we cross that bridge. But today, my lord, we are on a very limited clarification. Very limited.
Just show me the prayer in this eye. What prayer you want? You allow the present application seeking urgent hearing in view of the subsequent developments. So you have narrated the subsequent developments in your petition, right?
That's right, Lord. That's right.
Subsequent development, as you must be knowing, a subsequent development will be allowed only when you were unaware of these during filing of the main revision. Were you unaware of these?
Yes, because these are actually. These are only after this, and we didn't file the petition. The accused has filed the petition. These are all developments that have taken place thereafter, my lord.
Okay. That and yes. Okay.
And prayer 2 is really. Prayer 2 is really where the rub is, my lord.
There is no embargo.
There is no embargo, and because of para 12 of my learned friend's response objection, this can be clarified and disposed of, my lord. Because
then why in the nature of subsequent event? You can file affidavits bringing on record all these documents. Why in the nature of subsequent events?
Lord, we are bringing these developments by way of a consolidated application. Whatever, I'm not saying that believe everything and take away my learned friend's right to file a response to this. He has filed a response. Take both on record for the whenever the final hearing is done on the main matter. So prayer A, really speaking, is innocuous, my lord. Prayer A does not prejudice my learned friend because he will get a full-fledged opportunity to rebut these points. But as far as prayer B is concerned, prayer B is what I've advanced my submissions on, my lord, so that my lord can pass a suitable clarificatory order that the interim order of 7th March and the subsequent orders were never intended, my lord, to create any embargo on Section 19 power because that was not the subject matter of the present petition.
Okay. Now let me hear Mr. Das what he has to say.
Yes.
My lord, that is what my learned friend is thinking of 7/3/2025. When the matter was taken up by this court, never intended and never thought of Section 19 because our case was never a case of Section 19. What is why my learned friend requires a clarification of the order? If they have power to arrest, let them arrest. They doesn't have the power to arrest. That's the whole problem. I'll show the judgment of the Supreme Court where my learned friend appeared in Tarsem Lal case 2024. I'll show that. I'll show later on. First, I want to clarify that there are two orders which has been passed. We filed two petitions before this court. One is criminal revision, 3 of 2025, where we challenged the impugned order 13/12/2024, where non-bailable warrant to be executed. That the matter, what the court has done, and one criminal appeal has been filed for 1 of 2025, declaring me as a fugitive economic offender.
That has been stated.
Yeah, now both the matters came up before this court. But this is very interesting. I'll show it. Together the matter came up before this court. Both matter came up before this court. And there was a common order passed by this court. So it was, I will show it because I made a spiral binding.
Justice Kolita's order is a common order.
Kindly see. All orders, it is in the court's order, but for convenience of the court, kindly see. Yes. Both these orders, kindly see. One is criminal appeal 1 of 2025, and another is criminal revision. Kindly see criminal revision. Lordship, see. My learned friend is referring on 7/3/2025 order, and he wants that there should be a clarification and there is no embargo. Because as if no coercive measure means like not to arrest. What he is thinking of not to arrest. That was not the intention of the court. Kindly see. When this matter was taken up, my lord, compilation of revision. Kindly see the compilation of revision. Page 5, 7/3/2025 order. Which has been annexed by my learned friend.
Yes.
Kindly see now and see another order. One in one hand, keep that order 7/3/2025.
Yes.
My lord, in fact, I agree. My lord, in fact, I agree with my learned friend.
One second.
What he's saying is exactly what I am saying.
Let me complete.
For a change, both parties have had items.
Let me complete. I didn't disturb. Let me complete. I didn't disturb.
Very good.
Criminal appeal 1.
Compilation of the criminal appeal.
Yes. Lordship got it? Now kindly now you see 7/3/2025. This is a common order in both the case when the matter taken up, my lord.
Wait, how can I?
No, you see, my lord, both.
I'm taking up that revision compilation.
Yes.
Page 5, it's there with me.
Yes.
And criminal appeal.
Yes. Kindly see page 3.
Page 3 of?
Page 3 of criminal revision. See page 3.
Page 3 of the criminal revision.
No, criminal revision. See criminal revision, page 3. Now if you see the criminal revision 3 of 2025.
Page 3 of revision, yes.
That is 3 of this compilation. There are two compilations, 3 and 4. 3 and 4.
There are two compilation, one
Yes.
in respect of criminal revision
Yes.
and one in respect of criminal appeal.
Correct. Put
Huh.
your lordship will keep both.
Yes.
And take criminal revision 3 of 2025.
Page
At
5.
page 3. Kindly see page 3.
Page 3.
That itself. What your lordship.
Okay,
Page 3.
Page 3, yes.
See criminal 3 of 2025. And
one.
see link case criminal appeal 1 of 2000. Lordship got it?
Yes.
Now page 4 link case IA criminal appeal 4 of 2025. Now please turn to page 5. Now see 7/3 2025.
So this is the common
order. Now
yes.
you see, now Madam, kindly read that order. Learned counsel so has entered appearance for respondent so and so to file his affidavit. Since he has entered appearance today for the first time, prayer is granted. However, the IA criminal 4 of 2025 is fixed on 13 March 2025 for hearing on interim period. Till the next date, no coercive step should be taken against the petitioner. So that is in respect of IA criminal 4 of 2025.
Yes.
Not in respect of 3 of 2025.
No.
Not you got my point?
4 of 25.
Yes. And see our prayer in IA.
Where do I get this?
Criminal appeal 1.
Criminal appeal 1, IA.
Yes. IA 4.
IA is not separately filed. There is no
Separately filed. Separately. It was disposed of.
Oh, it was disposed of. IA is not here.
It is disposed of.
Perhaps it is in the records.
Yes.
Just see, Mr. Courtmaster.
Yes.
Otherwise, what was the prayer in the IA?
Yes. Yes, sir, just see the copy.
Prayer in the IA was stay the order of FEO.
I will
and stay
what
the.
was the prayer?
Acha, let him complete, let him see.
Yes.
Yes.
This is the IA, okay.
See the prayer.
Acha. Okay. Stay all further proceedings before learned principal judge PMLA in ML number 1 of 24.
Yes.
During dependency, okay. So all further proceedings.
Yes. But
that's stay is of the FEO proceeding. FEO is different, my lord. Stays of the FEO. FEO is the fugitive economic offender proceeding.
Yes.
What is this 22/1/2025 order?
That is declaring me as a fugitive economic offender which has been stayed. Now what I am saying, 7/3/2025, no coercive step was taken in respect of criminal appeal, which, my lord, has culminated into a final order of 7/4/2025 where it was stayed. So that nothing, no coercive measure doesn't remain. It culminated into a final order, which is found on in 4, and that particular IA has been disposed of. IA has been disposed of. So no coercive measure.
That Justice Kalita's order,
Yes.
the IA is disposed of?
Yes.
Acha, okay.
So
then.
if that is disposed of 7/3/2025, which culminated into a final order of 7/4/2025, where is the question of clarification of 7/3/2025?
So coercive order merged and it is finished.
So can your lordship clarify the order? Clarification is not permissible. 362 final or your lordship knows that it is only that if they are agreed by that order, they have to go before the apex court, which they did not prefer. This is what I want to say. There was nothing to do with section 19. Now section 19, by judgment of Tarsem Lal, I'll show that judgment, which my learned friend also appeared. His name also reflected. We have seen. That says, at pre-cognizance stage, the IO, the investigating agency, has got a power to arrest. But once the post-cognizance stage, when it comes to the court, then the investigating authority doesn't have the power to arrest. That is why they want the indirect manner, so that your lordship will say that there is no embargo so far as section 19 is concerned.
Achha, this I did not know. What is the case?
That I will show it. I brought a judgment before this. Kindly see.
In the pre-cognizance stage, IO can arrest.
The power is there. Kindly see.
After this?
After post-cognizance, there is no power which is given
Cognizance
to the
is
IO.
taken, na? Here?
Cognizance taken.
Summons issued.
Yes, kindly see, my lord. Now, Para 29, kindly see. Para 29.
I'll respond to this on my turn, my lord.
Yes, yes. You'll have enough time,
Every
don't
time
worry.
to respond. Absolutely no problem.
Para 29 at this stage.
30 kindly see, 30.
30. Okay.
My lord, in fact, this judgment should be read as a whole. I think that's really, your lordship should read the judgment as a whole.
As a whole.
It's my
I'll read it,
request
don't worry.
to
Yes,
read
yes.
the judgment as a whole. Everything has been elaborately discussed by two judges of the Supreme. One is Justice Abhay Oak and Honorable Justice Bhoya. A very interesting and very important judgment in this case. See para 30, my lord. Once cognizance is taken of the offence punishable under section 4 of PMLA, special court is seized of the matter. After the cognizance is taken, ED and other authorities named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. The reason is that the accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after cognizance of the complaint under section 44(1)(b) of PMLA is taken by the court, ED and other authorities named in section 19 are powerless to arrest an accused named in the complaint. Hence, in such a case, an apprehension that ED will arrest such an accused by exercising power under section 19 can never exist. So, my lord, once the complaint was taken by the court and cognizance has been taken by the it is like 200 and 204. Your lordship will go into entire judgment. It has said what is PMLA and what is a complaint when it is filed. Like a charge sheet is filed, it is a complaint. And cognizance is taken under the CRP's 200 and 204. Everything was detailed discussed. Now kindly see in para 31. We are informed across the bar by learned counsel of the appellant that some of the special courts under PMLA are following the practice of taking the accused into custody after they appear pursuant to summon issued on the complaint. Therefore, the accused are compelled to apply for bail or for anticipatory bail apprehending arrest upon issuance of summons. We cannot countenance a situation where before the filing of the complaint the accused is not arrested. After filing of the complaint, after he appears in compliance with the summons, he is taken to custody and forced to apply for bail. Hence, such a practice, if followed by some special court, is completely illegal. Such a practice may offend the right to liberty granted by Article 21 of the Constitution of India. If ED wants custody of the accused who appears after service of summons for conducting further investigation in the same offence, ED will have to seek custody of the accused by applying to the special court. So where is the question of your lordship saying it will not be an embargo? That means your lordship is giving them power to arrest. This is what they want. Kindly see, after hearing the accused, special court must pass an order on the application by recording brief reasons. While hearing such an application, court may permit custody only if it is satisfied that custodial interrogation at that stage is required, even though the accused was never arrested under section 19. However, when ED wants to conduct a further investigation concerning the same offence, it may arrest a person not shown as an accused in the complaint already filed in section 44(1)(b), provided the requirement of section 19 are fulfilled.
I did not get this. However,
I am a named accused in this case. They can for further interrogation, for further investigation, they can. But if you are not named the accused, then only then you can do it.
Okay.
Here I have been named an accused. My lord,
That's not correct.
My lord, 1 of 2024, special case has been registered. Now, when the special case was registered before the special judge, before the special court, now summons were issued. These are all record. I made a compilation for convenience of the court. All the order of the learned trial court, I made a compilation. Now, when the complaint was filed, summons were issued. Cognizance was taken. 200 and 204, same procedure. Summons were issued. Our lawyer appeared, represented the accused. Now, we filed an application for personal dispense like 205. That also reflects on Tarsimlal. 205 application, same like CRPC. Now, we filed, that also personal appearance was dispensed with. that your lordship will kind each and every step up to 18/10/2024, because all the time when our lawyer appeared, an application are always filed that to personal dispense with, and that order was passed till 18/10/2024. So all has been complied. Now today, my lord, keeping cut short of the matter, now what my learned friend wants, 1/7/3/2025 order that is caused an impediment. Because there is no embargo, they can arrest. This is what they want. Why I will come and, this is not our case. This was not our case before this court. We challenged criminal revision by way of criminal order of 13/12/2024. What was that 13/12/2024?
Non-bailable
The non-bailable warrant. Now, if your lordship read that order was passed by the application filed by ED on an off date. When this proceeding was going on an off date, they filed an application, IA 2/30/2024, before the ED court. That a warrant of arrest was issued and warrant of arrest is pending. That they stated. So that was passed, and ex parte order was passed in that case. Now that order was put to challenge by us for modification of that order, and 5/9/2024 that matter was heard. ED was also heard. Then before the trial court said that how can you you can issue an order without hearing the other side, off date, an ex parte order. That order was recalled. That order was recalled, and the warrant of arrest was kept in abeyance. And 230 was restored to file, and said, okay, 230 which was filed, that will be heard. And in the meantime, non-bailable warrant of arrest was kept in abeyance. And the next date was fixed on 18/10/2024. Now on 18/10/2024 also, the ED did not supply us the copy. Our lawyer appeared on 18/10/2024. And 18/10/2024, court said you supply a copy of 230. And in the meantime, the order which was passed earlier on 5/9/2024, that will continue. So meaning there was warrant of arrest, that will remain stay. And my personal appearance was dispensed with for that date. And the next date was fixed on 12/12/2024. 12/2024, the ED. I have compilation, I have given for convenience of the court. 12/12/2024, my lord, the ED did not appear. So there were two applications before the court. One is the 230 application. Another application of date they filed, declaring on 24/10/2024, declaring me as a fugitive economic offender because a warrant of arrest was pending. But by that time, on 5/9/2024, that was kept in abeyance. So where was the question of 791? That is why detailed discussion was made in this application where this honorable court has stated that order.
Fugitive order.
Yes. Now 13/12, next date was fixed on 13/12/2024. 13/12/2024, the London Special Court has looked into the first portion of the order. He did not look into the entire order, whereby the warrant of arrest was kept pending, was kept in abeyance.
Lord, if my learned friend is arguing the main...
No, you have got a time. You have time.
No, I'm not objecting. I'm only saying if you're arguing the main case, then I will respond.
Let me come.
Then it can be taken up. You're arguing the main matter.
No, I am not doing the main matter. I am just saying what was the order that was passed. That your lordship should know what was the case about. Now, my lord, the order which was kept in abeyance by the learned special court on 18/10/2000, on 5/9/2000, that continued till 13/12.
So he did not appear, what he meant to say.
No, whatever, my lord, there is an order passed by the court. Now, all these matters came up, the order of criminal revision and criminal appeal came up before this court. We challenged both the order. And this order, in 3/2024, that 13/12/2024 was state that non-bailable warrant that was state. And criminal appeal 4/2024, that IA which has been filed in criminal appeal 1/2025, whereby declaring me as a fugitive economic offender. And on 7/3/2025, the order said not to take coercive measure. In the meantime, that merged with that order of 7/4/2025. So as such, today, there is no order of 7/3/2025. Where is the question of clarification of the order passed by this court? There is no occasion of clarifying the order. If there is no occasion to clarifying the order, where is that your lordship will entertain this IA?
As far as 7.3, yes.
And in criminal revision, my lord 3 of 2000, my learned friend has filed IA in criminal revision. Kindly see.
Yes, it is in criminal revision.
So where is that?
That's correct, that's
There is no order. No coercive measure in criminal revision 3 of 2025. It was only 4-1 IA. And that has been merged with the final order of 7/4/2025.
No, what he meant to
All-
say is,
Yes.
that was a common order.
Yes.
No coercive measure.
Yes.
That was what?
But you see, my lord will
Common
kindly-
order in respect of 3,
But
criminal appeal
see,
1.
Yes.
Yes.
But
And IA 4.
Kindly see the line of that 7/3/2000.
Yes.
However, IA criminal appeal 4 of 2025 is fixed on 13 March 2025 for hearing on interim prayer. Till the next date, no coercive steps should be taken against the petitioner. But now second line, kindly see, the criminal revision 3 of 2000 may be listed along with criminal appeal 1 of 2025. Now, that was a common. Thereafter, the criminal revision was taken up by the court.
No, yes,
Yes. Yes. Kindly see this line, mine is very clear, my lord. However, the IA criminal appeal 4 of 2025 is fixed on 13 March 2025 for hearing on interim prayer. Till the next date, no coercive shall be taken against the petitioner. So,
But
only
then-
in-
but
My
then-
learned.
Yes.
But then the stay of the fugitive
Yes.
was in respect of criminal revision 3.
No, 4.
No, that is criminal appeal. That is criminal appeal.
4.
Acha, what is this second
Yes.
order? 21/3/25?
Which order, my lord?
In your compilation, 21/3/25.
Which 3? 21?
3. No,
Please,
I mean,
10.
this is-
Yes.
21.3 is the stay. One is the stay of
1
NBW.
or 3? Your lordship is taking which compilation?
I know one thing. No, your compilation in respect of revision.
Revision, yes. Yes. Which one? 21?
The next order,
Yes.
273.
One second. 21. Yes. This is one, my lord, the criminal revision was heard, whereby that 13/12/2024, that the non-bailable warrant to be executed, that was
that
heard.
was stayed.
Yeah, that was stayed. That was discussed. Kindly see, my lord, at para 12, page 12, page 12.
Yes, I've got it.
Considering a submission made by learned senior petitioner prima facie case, it appears the order dated 5/9 has not been violated, and still the next date the operation of the impugn order 13/12 shall remain state, and a non-bailable warrant of arrest issued in pursuant to impugn order shall also remain state till the next date. Fix this matter, leave this matter again on Friday 28/3/2025. Now this matter has been fixed on 28th of this month. And see, kindly see criminal appeal now. See the another bunch criminal appeal. Another compilation. Page 14. Kindly see page 14 now. See page 14. See page 14.
This is in IA 4.
Yes. Now criminal appeal 7/4/2025.
Acha.
Lordship got it? Now kindly see if your lordship turns to
This
page
is that
24.
fugitive order, yes.
See page 24. 24 see para 23. The
Yes,
IA
accordingly
according allowed and disposed of. What was that? That was in a link case connection with 4. That is why it is disposed of. If it is disposed of, merge with that no coercive stay with 7/3/2025, merge with this order 7/4. Am I clear to your lordship?
But then that coercive order, that coercive action order
Yes.
is in respect of other two petitions also.
No. That
3
is
and
no, because your lordship IA. Kindly see C3 I. That line is very clear.
A
Kindly see.
line is there.
Yes.
But the fact remains that all the 3 petitions were taken up
No,
together.
baby, it has been taken up. We did not mind the prayer of may be listed along with criminal appeal.
That is
So
also
that
there.
is yes. Yeah, till and no coercive steps should be taken against the petitioner.
but still it seems this
No,
order.
maybe. Let us take for the instance that if your lordship saying that it is same, both is no coercive measure should
In
be
all the
taken.
three.
So if, but my interpretation is not.
No, yes,
Yes.
you have a point saying
Yes,
by
my
relying
whole
on this
thing-
line.
Yes.
But then fact remains it is.
No, where is the question?
The very fact
Where-
that it
where
is.
All right, I'll come to you.
Where is the question to clarification of this of the court that it will be no embargo for the ED to go ahead and arrest under section 19.
Actually, yes.
And
the
if you
prayer
want,
is, prayer is misplaced.
Yes, that's the case.
Because he cannot arrest after
They
the
cannot
cognizance
arrest.
order,
Yes.
as you have shown.
Yes, they cannot also record.
Subject to hearing me, my lord.
Yes, it's subject to
My
hearing.
lord,
That is
cyber-
what my observation
Yes,
is, not.
cyber case when my learned friend said lot of things, making prejudice to the court, lookout circular, these are all being put to challenge. What my learned friend is saying before Punjab and Haryana court, and that was stayed. We have annexed that order.
I'm
Not our lookout circular.
This.
That was not,
Lot of
Mr.
things
Das,
have
that
been
is not
said.
our lookout circular. That
730
is,
crores, 2035 crores, those are not the subject matter of this court, my lord.
So what?
Not the subject matter.
I'll just go strictly with
Yes.
clarifications.
Yes.
So first of all, he said
may I respond, my lord?
75.
Yes.
Now, after I get his response on this,
Yes.
73/2025 order.
Yes.
Yeah, you have although it was a common order, but then you said it was in respect of IA4 only.
Yes.
Yes, which got merged with 7/4.
Yes,
2025
right.
order, and so 7/3 does not subsist.
That's
It's
what
gone.
times, yes.
Then 13/3. What is 13/3? 13/3 order that he has said.
13.3.
13/3 order is this. 13/3 order is in respect of the same revision.
Yes.
13
Continue.
Achha, where is Mr. Hussain? Where is 13/3 order?
At page 8. Kindly see page 8 of the compilation. Or of the revision.
13/3.
Yes.
Achha, 13/3 is a subsequent order.
Yes.
Ad interim order passed on Iman shall continue.
Yes.
It was before 14/4 where it got merged.
This is a
Right.
common order. Common order. Kindly link is
Same.
Seven, yes.
Which
Link
got
is-
merged with your
Yes.
final order.
Yes.
Right. Okay. Then 21/3 is
This
what?
is page 9. Page 9.
21/3 is what
Yes.
happened, or that NBW is state?
State. State.
Correct.
Yes.
So 13/12/24 interim order is given.
Yes.
Then 28/3.
Page 13.
28/3 is in
Page
respect of
13.
revision.
Page 13. They said
Acha.
that leaves this matter.
Interim
So,
order means
Interim order shall
the
continue.
stay of the
Non-bailable
NBW.
warrant. Yes, right.
NBW
ED may
was.
file written objection or not before the state date.
Then 28/4.
28/4, page 15.
Yes.
Submitting
this is-
ED will submit affidavit reply and the petition applicant willing to submit rejoinder against the reply.
Interim order is
Yes.
extended again.
Yes,
So
right.
28/4.
Yes.
So okay, these are all subsequent orders.
Yes.
26/5 is also
Yes.
same.
Yes. Then 17, Lordship got it. Then next is
Clarification, inherent power.
26/5, 2025. There's a, yes, Lordship got common order.
26/5.
Yes.
26.
Page 18.
Yes. No.
Page 18.
No, 20.
26/5.
23/6.
23/6, your Lordship got already.
26/5.
28/4.
26/5 is also a common order.
Yes.
That 1/4 is gone.
Yes.
Linked cases criminal appeal 1.
Yes.
So that IS disposed of by
Yes.
them.
Yes. Last is 23/6/2025. 23/6/2025.
Yes. Okay.
So that
And
will
there is
continue
no
till the next
embargo.
day.
And as far as the clarification of these orders, I don't think so.
So
There is
now
any
your Lordship will kindly
disputes.
see if the interim order in Criminal Union 3 of 2000 shall continue till the next date, and if your Lordship now think that no 7/3/2025 no coercive steps would be
that
taken.
has no connection.
No connection. That is what I am saying.
Subject to what he
your
says
Lordship
again.
will like overreaching a particular like an order which has been passed by those by your lordship predecessor, by the judges.
Because after the
And by going to the controversy, Tarsem Lal is against them. You'll obviously
that
see
is
that.
again a separate.
Then how your lordship will clarification of the order, giving a clarification of the order amounting, what do you want? The Supreme Court's order. Can your lordship overreach the order passed by the apex court? And whatever application you have to file, go and file before this special court. Whatever application you have to file.
You file application for
Yeah,
transit,
file.
bring him here.
Yes, whatever application. Your lordship doesn't have to clarify all those things. So this IA is not entertained at all. IA should be dismissed, my lord. In Tarsem Lal, judgment, it should be dismissed, IA.
Acha, Mr. Hussain.
And I will just request your lordship, please go through Tarsem Lal judgment.
May I place Tarsem Lal straight
And
away?
what
Now?
lordship-
I'll ask you before.
My lord,
Ah.
ED, I don't know, one of the senior counsel who appeared for the ED, what he said, once the summon is issued to an accused in a PMLA case by a complaint where cognizance is taken, once he appears amounting like he's in custody of the ED. That was submission. It was negated by two judges of Supreme Court. He said, what do you say? By appearing itself, it becomes under the custody. With greatest respect to my learned friend, we also look into what is going in Supreme Court. It's not that we are not aware what is happening in Supreme Court. Honorable Chief Justice Gauhati on that day has commented, the ED's conviction rate is only 5%.
I'm sorry, how are these relevant?
They want only
These are
confiscation.
completely-
They
how are
want
these
only
statements
confiscation,
relevant? Wait,
and they want only confiscation of the property, and they will put to auction. That's the whole idea. What is the conviction rate? Tell me, my lord. What is the conviction rate of PMLA?
These are all
They
prejudicial
all
statements
need-
being made.
I don't want to go into merit of this case. We'll address at the proper time.
Yes.
2035 crores, 900 crores in gaming and betting, and what has got a connection with predicate offense here?
Okay.
Nagaland.
It's okay. Mr. Hussain, what do you have to
I
submit?
have made a note. I'll give a note to my learned friend.
Yes.
Now,
Yes.
please see, my lord. If
No,
my
before
friend will-
before you start, I'll put
Yes.
suggestions.
Yes,
One
please.
is that your eye is confined only
made a
to
note.
clarification of the orders, and that 19 will not apply. There is no embargo, right? Now,
That's right.
as far as clarification, what I can see from the orders is that
Yes.
2024 order has merged into the order where NBW was state, or where
That's-
fugitive thing is state. So
in
that
fact,
is
in fact,
wrong.
I'll cut short, my lord. 90% of what my learned friend has argued is in my favor, and is therefore a ground to, in fact, permit the IA. 90% of what he's argued, because what has he said, my lord? First thing he says, where both parties are ad idem, that interim orders have nothing to do with Section 19. I'm only quoting. I've written down verbatim what he argued.
But
My learned
that is okay. But section 19, there is an embargo. You cannot arrest after.
I'll come to, my lord, my learned friend has not placed all paras. I was there in Tarsem as a counsel. I'll place all paras and I'll show the power. The
Make
Supreme
it short,
Court,
make it short. It is I only. Okay.
please come to Tarsem straight away. And while noting, please come to, my lord, Tarsem para 32. My learned friend is arguing what he should be arguing, my lord, if he appears opposing remand of this person. This is not the subject matter of present proceeding, but nevertheless, I'm clarifying it. Please see para 32. My lord, it starts with coming back to the facts of the case before us. I hope, my lord, it is the same para.
Yes, yes.
Warrants were issued to the appellants as they did not appear before the special court after the service of summons. As held earlier, the appellants could have applied for cancellation of warrants issued against them, as the warrants were issued only to secure their presence before the special court. Instead of applying for cancellation of warrants, the appellants applied for anticipatory bail. All of them, please mark this in, my lord, with an underline, my lord. All of them were not arrested till the filing of the complaint and have cooperated in the investigation. Therefore, we propose to direct that the warrants issued against the appellant shall stand cancelled. This is reiterating the principle right from until to Siddharth that if you have cooperated and you've not been arrested, then post cognizance you will not be arrested or taken into custody. Now please see how the court carves out an exception at para 33.10. Tarsem was a case where they were cooperating throughout investigation till the filing of the complaint. Unlike my learned friend's client, 6 summons issued, reported, not cooperated, not appeared, not available during investigation. Now please see 33.10. And he's a person who is a fugitive economic offender. Stay does not efface the order. Stay only means don't give effect to it. Now please see 33.10. If ED wants custody of the accused, so custody is not foreclosed. If ED wants custody of the accused who appears after service of summons for conducting further investigation, which is what we are doing right now, in the same offense, ED will have to seek custody of the accused where, my lord? By applying to the special court. My learned friend wants my lord to rule upon Tarsem because, my lord, my learned friend will get some sort of a benefit when we seek his remand in the special court. Therefore, my humble submission is, my lord, the scope of the present IA, the scope of the present petition has nothing to do with Tarsem. Please don't rule upon it because it will prejudice my trial court proceedings, which Supreme Court says, this is Justice Oak's judgment, my lord. Please, I'll read this one more time, my lord. If ED wants custody of the accused who appears after service of summons, my learned friend has not appeared after service of summons, my lord. He has been arrested by a different agency. He's been picked up when he was found that he is coming to the country through illicit channel. For conducting further, ED will have to seek custody by applying to the special court, which we will, in accordance with Tarsem. After hearing the accused, the special court must pass an order on application by recording brief reasons. My learned friend wants to preempt this proceeding under 33.10. While hearing such an application,
If you want to arrest, you have to again apply to the special court.
I'll do everything. I will do everything required in law to do so, provided Tarsem applies. I will argue that even Tarsem, my lord, because of para 30, please see para 32 one more time.
What is the connection with these clarification of the orders?
That is what my learned friend has argued. This was never my argument. My learned friend brought in Tarsem has...
You have prayed in your eye, right?
Yes.
Well,
Yes.
what is the connection with the prayer? You can always do it by applying for the special judge.
That's all I'm saying, my lord. Today, my only prayer is, please come to my prayer B. My only prayer, if my learned friend has a problem with the word embargo because he feels his proceeding before the trial court will be prejudiced, my lords can always clarify that the interim orders are only with respect to the NBW and not in respect of 19. If the embargo word is causing a problem, in fact, both of us, 90% of our arguments are ad idem. My learned friend says 7th March, no coercive order is not any subsisting. My lord can record that submission of his and dispose of my IA. That takes care of me. My learned friend says that the interim orders were not in relation to section 19. My lord can record that statement and dispose of my IA. I will not need any clarification because it's my learned friend's statement. No, dispose. My learned friend can't dictate what is to be done. The court will consider it.
But as far as your number 2 prayer, I don't
Yes.
think so because 7.3, I have seen all the orders. 7.3 orders, no course, got merged with I4's order.
Please say that. I have no problem. Today,
And then
please
all
consider
other
the bona
orders
fide.
are okay. But
Consider the
embargo,
bona fides.
there
Lord,
is
consider the bona fides of the
embargo.
agency.
What I'll say, what I'm thinking is, I'll say that there is no question of any embargo on 2019. You can always go and arrest after filing an application before the special judge.
No, 1 second, my lord. I just want to say this. Whether or not I need to file an application before the special judge is also a question because of para 32. My request is whether I need to file an application or not need not be ruled upon in this IA. That's my request. Please see para 32. He does not get the benefit of Tarsem because of para 32. Tarsem was a case where they had cooperated, made themselves available during investigation.
We are not into facts. Here the law is, after cognizance, one cannot
Yes.
go and arrest unless it is allowed by the special court.
No, please see. That is not the law, my lord. The law is, please see, my lord, Tarsem was passed after Satinder Antil, which was a 3-judge bench. Please see Satinder Antil for one moment, my lord. The judgment of Satinder Antil, if my colleagues can hand it over, or if the court, my
Attended
lord,
until, okay, 41A notice and all. What do you want to place from there?
not 41A alone. Para 89 of Satinder Antil, I'll read it, my lord. It is only in a case where the accused is either not arrested consciously by the prosecution or arrested and enlarged on bail, there is no need for further arrest at the instance of the court. That is post cognizance. This is not a case where the accused was not consciously arrested. This is a case where the accused was never available from the day the first summons was issued all the way up to 6 summons.
Those are not before me in this IA.
Therefore,
What I
my
have-
request is
Yes. What
even
about your-
Tarsem.
Yes.
My lord, even Tarsem is not before the court in this IA, my lord. That my learned friend wants a ruling that Tarsem, he wants the benefit of Tarsem. My request is that is not the subject matter of the present petition. All that the clarification that we are seeking is that these orders are not with respect to the section 19 power. So, my lord, may leave it at that, because whether Tarsem applies or not is a subject matter that the special court has to adjudicate, my lord. We will be prejudiced, multiple prejudices will happen if my lord comments upon Tarsem without the entire facts of the case. And facts have to be seen. My lord is right that this does not, Tarsem is not concerned in this IA. I am not seeking permission. If I were to seek permission to arrest of the accused, my lord would be entitled to rule upon Tarsem. I am not seeking permission to arrest from this honorable court, my lord.
No, in fact, section 19 will not come in this case. You have filed your IA in the criminal revision. And the criminal
Yes.
revision is only in respect of what?
Only in respect of the NBW. So that's the only clarification. My lord, that's the my lord, now. my
Why
lord,
do you need a clarification from this? There is no need for any clarification. You can
now
go
please
and
see. Please see, my lord, the problem.
Yes.
That's the only few lines I
It's
see.
not a subject matter of this revision.
Then my lord may say so. That's all I'm saying. What my learned friend says, what
Okay,
the
I'll
court is
pass
saying.
orders. I'll pass
Yes.
orders.
My lord, only one submission.
Yes.
Only one request, my lord. My lord, in this case, my lord may see, parties are ad item.
And
that
what
the
about your
interim
number
office-
one prayer? Prayer number one, allow the
Prayer
present
number one is,
urgent hearing in view of the
my lord,
subsequent.
that my lord may say because the matter is coming on 28th of July itself, that my lord may say that it is coming on 28th July. First matter, first prayer,
Your Lordship,
it is coming.
the first prayer was added because the application was filed in the vacation. So that is why the
Yes.
first prayer was added, Your Lordship.
Yes, so in any event that is coming on 28th July, so the first prayer can, my lord, accordingly be dealt with, because main matter is coming on 28th July.
28th July. Okay.
Yes. Insofar as, my lord, the second prayer is concerned, the very fact, my lord, that these orders has consumed, clarification of these orders has consumed almost 2 hours of hearing, means some clarification is required. Because, my lord, there is some ambiguity.
Clarify, but then I'll pass my order. It's okay.
Yes, I am not seeking permission for arrest. I am not saying, my lord, we will do everything in accordance with law. My lord can record that they can seek arrest in accordance with the law laid down and the principles laid down by
My
Supreme Court.
submission is I just giving a reply to my learned friend. Tarsem Lal has been shown because I want to show before this honorable court the power of the ED. What is the law under 19? Because I have shown my learned friend said that why he wants to take benefit. There is no question of taking any benefit. What is the law I am showing? Because my learned friend in prayer is saying if there is no embargo excess of power under section 19. Why he has made that prayer?
There is no connection.
That is what I am showing it. Tarsem Lal, your lordship should know the judgment. My learned friend appeared in that case. My lord, he should have first placed that judgment. This is what the judgment is about. My lord, some judgment goes against us. The duty as a senior counsel to point out. Sometimes inadvertently it happens. Some, my lord, some instruction is given. We also don't know some instruction. But I am not saying that my learned friend has misled the court, but the question is that Tarsem Lal should have been addressed before the court. My learned friend has appeared. Why this prayer has been made? My humble submission, nothing remains in this case. One, if one has been fixed on 28th of this month, that is Monday, it has been fixed. Both the case. So that goes. Second is that there is no question of clarification of 7/3/2025. It has merged with the order. Once it is merged, it is closed. My lord, where is that, my lord? 362. Where is that your lordship can clarify that order? Clerical or arithmetical error under 362, your lordship can pass. And only this CRPC.
362 will come when final judgment.
Final or
this is actually.
IA disposed of.
This is an interim order.
IA has been disposed of. It has attained finality. IA is concerned. Now there is a case where IA disposed of. You can go before the apex court against that order. It has been disposed of.
I'm not
No,
challenging
I'm just
that
saying,
order here.
it is
I'm
finality
not challenging the
of
order.
IA.
My learned friend is
That is
misconstrued
why
my
I'm saying
IA.
there is no question of clarifying this order. Clarification of the order means that your lordship 362 kindly see.
There is no embargo. There is an inherent.
Moreover, it is his revision. It is.
Of course.
It is the petitioner's revision. You
Now
cannot
I'll point out.
relief in his petition.
And kindly,
No, I'll point out one thing, my lord. One more thing, my lord. My learned friend will permit me only.
Prayer number 1 to allow the applicant seeking urgent hearing in view of subsequent development in the case pertaining to arrest of Bhupesh Shara and FIR in cybercrime. What is urgent? What relation he has got in that in Faridabad case with this case? What is it?
I'll point out. I'll point out the relation.
Is there any record?
I'll point out the relation.
If there
When
is
a
a
person.
urgent, you have to place
No,
some
no,
record.
I'll point
What
out
is
the
the
relation,
record?
my lord. A person who was a fugitive, a modern day cyber criminal dealing with hundreds of crores of person who was a fugitive, not being apprehended.
Which is not a part of record.
If he is apprehended, is that not a subsequent development? Open-ended NBWs were live. Open-ended NBWs were existing. He was declared a fugitive. What is a fugitive? Person abroad refusing to come
No,
to
in
India
fact-
to face trial.
No, Mr. Hussain, the law as it is, what I know is subsequent events can be placed during the pendency of the appeal.
Of course, I can place it.
With additional prayers. It is only to bring into record the subsequent events.
Yes.
Prayer
If
is
the-
by
if-
the petitioner.
If the additional facts.
By the petitioner.
Now, please consider only one thing, my lord. My learned friend is not permitting me to speak. Please consider only one thing, my lord. If we had gone and arrested him, I am sanguine that my learned friend would have filed a contempt petition before my lord. Look, there's a no coercive. How could they have arrested him? To avert any kind of a possibility of that kind of argument out of the bona fide of the agency, we are before the court saying, please clarify that this has nothing to do with 19. If embargo is troubling my learned friend, my lord may not leave all those issues to open to be argued before the special court. But at least this much clarification, and my learned friend is ad idem with me, that this much clarification that these interim orders were in the context of NBW and not under 19. If the word embargo is troubling him because it may prejudice him, my lord may not say anything about embargo, but my lord may say that these interim orders were passed simply in the context of the NBW.
Now he is modifying, he is saying something which is not a part of that.
Please, the court has the power.
Okay, I'll pass orders.
Yes.
I'll think over. I'll not
Yes.
dictate now. I'll think over
And
I'll-
I am not seeking a review
My
of
lord,
the order.
my
I am
whole-
not seeking the court to be in appeal. I am not seeking any such relief. I am only, my lord, out of please consider the bona fide of an agency. We are before the court because there were two orders, no coercive and an order saying NBW. We wanted a clarification that the no coercive is no longer alive. My learned friend says no coercive is no longer alive, then that's the end of the matter.
Then why
it
you
is
need
his
a
submission which helps me. No, that can be recorded and the IU can be disposed.
Achha, I'll write the beginning, first part. This interlocutory application is filed with two prayers. One, to present allow present application seeking for two prayers. One, for urgent hearing of the instant criminal revision petition being number 3 of 2025 in view of the subsequent developments in connection with the FIR number 24 of 2024 registered by the Cyber Crime Police Station, Faridabad. And number 2, for clarification of the orders dated 7/3/2025, 13/3/2025, 21/3/2025, 28/3/2025, 28/4/2025, 26/5/25, and 26/2025, with an additional prayer that the said orders do not put any embargo on the exercise of power under Section 19 of PMLA Act. Full stop. Mr. Hussain, appearing for the applicant, states that by order dated 7/3/2025, a direction was made for no coercive action. Direction was given for no coercive action against the petitioner to be taken against the petitioner. No coercive action to be taken against the petitioner. And the same order was passed in respect of the instant petition. And thereafter, he places the order dated 21/3/2025, by which this Honorable Court had stayed the impugn order dated 13/12/2024, challenged in the instant criminal revision, was stayed. Impugn order dated 13/12, as well as the non-bailable warrant of arrest passed in the criminal revision petition 3 of 2025 was stayed. The learned counsel therefore prays as to whether, in view of the order dated 21/3/2025, the order of 7/3/2025 still subsists.
And in any event, this has nothing to do with Section 19. That's my second submission.
19 I'll come
Yes,
later.
yes.
And then he has also prayed that the subsequent orders may also be clarified, which were passed in the instant revision petition as well as in other analogous petitions. He has also prayed that the said orders passed in the various applications, such as the criminal revision petition, the criminal appeal, as well as the interlocutory application. Well, how did I start? He has also submitted? Have not put any embargo on the department to arrest under Section 19 of the PMLA Act.
Lord, I also relied on para 12 of his objection, my Lord, to say that there's a...
Okay, let all come. Mr. B. Das, assisted by Mr. S. Das, submits that the said prayers do not need any clarification, inasmuch as the order dated 7/3/2025, which was passed in respect of 3 applications. That is the criminal, that is the that is the criminal revision 3 of 2025, that is the present petition, as well as criminal appeal 1 of 2025 and IA criminal number 4 of 2025, and the said order was a common order. He thereafter pointed out that in the order dated, where is that order of 7-4? It is in the criminal appeal, no?
Yes.
What did I say? He thereafter pointed out that in the order dated 7-4-2025, before that you're right. He submits that although all the three applications, although the said was a common order, although the said was a common order, but the language of the order reflects that the same was in past in connection with IA criminal number 4 of 2025. He thereafter placed the order dated 7-4-2025 passed in connection with IA criminal number 4 of 2025 as well as criminal appeal number 1 of 2025, by which the learned court had stayed the order dated 22-1-2025, by which the petitioner was declared as a fugitive economic offender. And by that order, the interlocutory application of 4 of 2025 was allowed and disposed of. As such, he submitted that 7-3-2025 order merged, which was passed in connection with the said interlocutory application, got merged with the order dated 7-4-2024. 2025, and that the order dated 7-3-2025 does not subsist any longer. And as such, he stated that there needs no clarification as far as those orders are concerned.
One more submission, 7-3-2025, if you take as criminal revision of 3 of 2025, that also merged with the order of 13-12-2021-3.
No,
That
even,
order.
even if it is passed under
7-3 in criminal revision 3 of 2025, which is a subject which my learned friend said, that also merged with the order of 21-3-2025.
Yes.
That is my submission also.
That also merged.
That is my submission also. We are both saying the same thing. That is my submission also.
Okay. He further states that even if the order dated 7-3-25 is considered to be also in connection with the instant criminal revision, that is revision number 3 of 2025, the same get merged with the subsequent order dated 13-3-21-3. Get, no, 21-3, right? Page
21-3, that's right.
Page 9, that is 13-3. Page 9 is 13-3. Page 9 of the compilation of criminal appeal.
No, my lord, it is a criminal revision.
Wait. Page, this is 21-3 order. Yes. And wait, 9-3 was fixed on 13th March. Where is 13-3 order?
13-3 order.
That is okay. Then 21.3 is in respect of revision, right? He also stated that 7.3.25 order, even if it is, I've said this, no? Even if it is, okay, get merged with the order dated 21.3.2025, passed in the said criminal revision, by which this honorable court had stayed the operation of the impugn order dated 13/12/2025, by which the non-bailable warrant of arrest was stayed. 24, yes. By which the non-bailable warrant of arrest is stayed. He further submitted that the clarification required in respect of the subsequent orders has no basis, since the subsequent orders were only passed by which the interim order of staying the NBW were extended. Right? These were all extension orders. He as such prayed that the clarification sought for in respect of these orders have no basis at all. He further submits that the further prayer of the applicant that there is no embargo on the exercise of power under section 19, he submits that the same is not required in the facts and circumstances of the case, since it has no connection with the criminal revision filed by the petitioner, in which this I is filed. He placed a judgment of the Honorable Supreme Court passed in Tarsem Lal versus Directorate of Enforcement, Jalandhar Zonal Office, Jalandhar Zonal Office, by which reported in 2024 7 SCC 61, 24 7 SCC 61, by which the Honorable Apex Court had returned a finding that the Enforcement Directorate has no power to arrest after cognizance is taken in respect of the complaint filed by, after the cognizance is taken, right? Okay. After the cognizance is taken. After the cognizance is taken by the trial court. He placed paragraph 30 of the said judgment, which is reproduced below. You just placed this X2. You have also placed 31, right? Yes. Paragraph 30 and 31, which is reproduced below.
And he has been named as an accused in the complaint. Wakil number 1 in the complaint. Yes.
It is made clear by the Honorable Supreme Court that in cases where cognizance is taken and the ED seeks to arrest or ED seeks to take accused in custody, the ED has to do it by applying to the special court.
19 it becomes a powerless. Can you see the word? Powerless. That word has been given.
In paragraph 30?
Yes, 30.
Last line. Hence, in such a case, an apprehension that ED will arrest such an accused by so and so can never exist. No. There's something more. Okay, I will extend on that. In respect of the said submission, the Mr. Hussain appearing for the ED submits that in the said judgment it is also reflected that if the ED wants to conduct a further investigation concerning the same offence, it may arrest a person not shown as an accused in the complaint filed.
No, shown as an accused also. I can arrest a person shown as an accused in the complaint filed if he was not available to me.
But here
Not
it is
shown.
not shown.
No, please see 33.10.
He had placed paragraph 33.10 of the said judgment, wherein it is reflected.
My lord, there are two aspects to 33.10.
See para 30, my lord. Your lordship is looking para 30. Therefore, one first, second, third, fourth, fifth line. Therefore, after cognizance of complaint under section 44(1)(b) of PMLA is taken by the court. Lordship got it? ED and other authority named in section 19, other so and other authority named in section 19 are powerless to arrest an accused named in the complaint.
There is a caveat to this in 33.10. Please only have 30. There is something very important, my lord. Because
It's okay.
powers.
We need not go in details into this. So what I'm just writing.
33. Yes, I'm only clarifying one thing, my lord. 33.10 deals with two aspects. One is where ED will seek custody of the person who has been summoned upon cognizance by the court. Please see the first line. If ED wants custody of the accused who appears after service of summons for conducting further investigation, ED will have to seek custody of the accused by applying to the special court.
This is what I say.
This is service of summons by the
arrest, but then after applying it to the special court.
Yes.
He also submits paragraph 33.10, wherein it was stated that if the enforcement directorate wants to arrest a person after the cognizance is taken, the ED has to seek custody by applying before the special court. So as such, he submits that there is no embargo on the ED to arrest accused even after the cognizance is taken, right?
Yes, because my lord,
that's
right. Because special court, my lord, tomorrow if my learned friend says that tomorrow.
Not under 90 by applying, yes. That
tomorrow, my lord,
my finding.
My lord, tomorrow under even this is under 19.
The application is only to the
just 1 second, sir.
His judgment
just 1 second, sir.
Before the court. His applications were rejected because there is no connection with 19 in this case.
This is what
that he wants.
That is
how can you preempt?
He wants some order from the court, so that indirect he wants an order from the court.
It's okay.
I don't want that indirectly, my lord. I don't want it indirectly, my lord. I can apply. My learned friend has some misconception about the law with great respect to him. Even when I apply to the special court, my lord, even when I apply to the special court, that is a power I exercise under 19, but with a prior permission of a special court. Even when I apply to the special court. So, my lord, there is no embargo insofar as if a person is not available during investigation, even qua him, I can arrest him after filing of a complaint, after cognizance is taken by applying to the special court. That power is also a power under 19, but with a prior application to the special court, my lord. There is some misconception, my lord, that my learned friend has. Because please see para 33.10.
Any misconception, the judgment of the Supreme Court is very clear.
No, but then
therefore we will argue that out. Therefore we will argue that out in the special court. That this is not the
30.10 is in respect of the facts of that case, not the facts of the present case. And that
therefore the facts have to be seen.
Principle, we are on the law. What is the principle that has been laid down?
33.10
I have
is the
understood
principle.
the contents, how your lordship interpret, but Supreme Court is very clear. Pre-cognizance stage, you have got the power of 19. After post-cognizance, you don't have a power, you become a powerless. Now you come to the court and you want a clarification of 7.3. That was his argument on the last occasion where he said, yes, my lord, we want some clarification of 7.3 2025 order.
No,
So
what
there is
he
no embargo.
What he is apprehending, what his
Now-
apprehension is, if he goes to the court to get a permission to arrest, then you might file an application saying that no, there is a coercive
No,
action.
no. That your,
And that
what
court
your
can't
lordship-
clarify it, my lord.
Yes, your lordship. What
The
was
special court can't clarify that,
clarification
my
of
lord.
the
That-
order?
No,
There is
that
no
of course.
clarification of the order. And
No, my lord, may
secondly,
please
what is the
see
difficulty? I am telling you why ED is finding it difficult. Warrant of arrest has been stayed because of this special court, PMLA. If warrant of arrest has been stayed by the High Court, how can they apply before that court? How?
We can, there is no
Your
embargo.
lordship,
These are two
you do it. ED
two
is
different
doing
kinds
it.
of arrest.
That is why the Honorable Chief Justice has said, enough is enough by the ED. We are saying that order when Kapil Sibal has moved the matter.
I'm sorry,
Your
which
learned friend was
court,
present
which case?
in
My
that court.
learned friend is mixing up
Yes.
issues.
Moreover,
Today,
he is a
today-
respondent, he
No,
cannot apply.
My lord,
cannot-
whatever, yes, that's the whole
He
case.
cannot pray
You
in your
cannot
application.
Pray my application.
That is
And
there.
secondly,
My
what
lord,
the court has
clarification is
said,
an inherent
but
power of the
today,
court.
He wants a handle that no, see, High Court's order is there under section 19, no embargo, so we should arrest. I have not come across, I have read the judgment 10 times I have understood, they become powerless only at the investigation stage they have the power. After 19, they become, after the cognizance is taken, they become powerless. That's the judgment says.
Okay, these are your submissions. I will,
My lord,
I will
only
pass the order.
one submission. Please see explanation 2 to section 44. Please have section, only one section, my lord, Missy. My learned friend says we become powerless despite 33.10 para in Tarseb. Despite Supreme Court saying that if a person is not cooperated, you can, even after cognizance, you can arrest. Please
Where
see
is
section. Please see section 44, explanation 2, where my learned friend himself concede to the fact that during investigation I can arrest. Please see explanation 2. There is a deeming fiction in the special law 44D small Roman 2. Please see that, my lord.
The complaint shall be deemed to include.
Yes, the complaint shall be deemed to include any subsequent complaint in respect of further investigation that may be conducted to bring any further evidence, oral or documentary, against any accused person involved in respect of the offense. Now, please see the next sentence, my lord. Very important words. For which complaint has already been filed, whether named in the original complaint or not.
This
So
is
for
something
Bhupesh,
like, 170.
yes, yeah, this is slightly modified version of 173.8. 173.8 is supplementary charge sheet. Mr. Das, he's a senior counsel, my lord, keeps interrupting. Supplementary charge. Then permit me to finish, sir. Then I will also not extend courtesies to you if you do this. Please see, my lord, a supplementary charge sheet under 173.8 is qualitatively different from clause 2 because there is a deeming fiction. Under the please see the first 3 lines and words, my lord, of this. There is no similar, it's a sui generis legislation, no similar provision in 173.8. The complaint shall be deemed to include.
Yes, shall
It
be.
is akin to 173.8, but it is qualitatively much more higher. The complaint shall be deemed to include any subsequent complaint in respect of further investigation that may be conducted to bring any further evidence, oral or document, against whom? Against any accused in respect of the offense for which complaint has already been filed, whether named in the original complaint or not. So you could be a new accused, or you could be the same accused against whom more evidence is being brought. Arrest is an inherent part of further investigation. Therefore, keeping all this in mind, Justice Oak in para 33.10 says, even after cognizance, even after summons, you can arrest, but apply to the special court.
Okay, I'll decide on that. Yes.
Deeply obliged.
It's okay.
Deeply obliged. Thank you.
Mr. Burago's matter, I'll take it up at you.
Yeah, yes.
After this, I think.
Yes. Thank you.
Just for mention video without any doubt. Motion anyway, let's see. Just follow and see. That's good. Rohan and Ankit Kala, they appeared on this. So you see, yeah.
I was very interestingly, I was observing the earlier matter which Das sir was arguing.
Yes.
My Lord, may I kindly look into one judgment of the Supreme Court in that matter.
Acha.
Yes,
Just
so
tell me
I will give you the I will give my Lord the citation.
Huh.
Just an academic point of view, since the issue of cognizance which your Lordship was referring, Supreme Court has said cognizance under the PMLA cannot be taken until and unless the accused has been afforded hearing.
Okay.
Okay. So now, if your cognizance has not been taken, arrest that issue also. I believe that what ED is arguing that counters. It goes against them. Yes.
Give me that judgment.
Yes, to take that judgment. I will give the judgment, madam.
My lady, we still have two motions. Councils are here.
Oh,
Two
motions.
which was
Okay.
passed over.
Before Mr. Siddharth, there are two motion matters. What?
Okay.
For motion, item number 4.
4. Yes.
May I please, Your Lordship? Your Lordship, this IA is filed for the purpose of implementing Sri Zarentang Izong IAS. The
Impleading.
Yes.
Impleading somebody.
Yes, Your Lord. No, Your Lordship. The respondent number 2, read as the Commissioner and Secretary. The then Commissioner and Secretary has been transferred to other department, Your Lordship.
Okay. You want to implead Principal Secretary as of now, whoever is now.
Yes, Your Lordship. The present, yes.
Now he is
as respondent number 4.
Okay. This application is filed for impleading of Sri Zarentung Izung Zarentung, then EZUNG, IAS, Secretary Public Health Engineering.
Secretary to the Government of Nagaland.
What you have written is Secretary Public Health Engineering Department.
Yes, Your Lordship. In my paragraph 3,
Huh.
it has been written as a Secretary to the Government of Nagaland. So that
IAS Secretary to the Government of Nagaland.
Yes, Public Health Engineering Department.
Public Health Engineering Department as a necessary party. No, not as a necessary. As respondent number 4 in the original contempt petition number 7 of 2025. Miss So-and-so, appearing for the applicant, or appearing for the petitioner, states that respondent number 2, who was the Principal Secretary to the Government of Nagaland, PhD department, has been transferred, and in his place, Mr. So-and-so has been appointed, and as such, she prays that Mr. So-and-so, the Secretary, may be impleaded as respondent number 4. Prayer is allowed. The necessary application, the amended cost title, right?
Yes,
the council is permitted to file the amended cost title. This petition is disposed of.
Okay.
Okay, you file the amended cost title.
Yes, Your Lordship.
Anything more?
For motion, item number 5.
She has to say
There is the
something.
same prayer, Your Lordship, except
Oh,
that
acha.
respondent here, the then Commissioner and Secretary is respondent number 2. So now the present respondent is to be
same
implemented
person
as
you are-
respondent number 5. That's the only difference, Your Lordship.
Okay, a same prayer will be there, but then what you say is in place of respondent number 2.
Yes, respondent number 4.
5.
Yes.
He will be now as respondent number 5.
Yes, Your Lordship.
Right, Commissioner and Secretary, and this is Commissioner. What is the difference between 2 and 4?
It is the same 10th Commissioner, Your Lordship.
Now 4 is still there.
4 pertains to the previous one, Your Lordship.
And 2
now,
also before that?
Yes, 2. Now,
Okay.
the present respondent should be respondent number 5.
5. Okay.
Yes, Your Lordship.
And these, they have been transferred?
Yes, same, Your Lordship.
Same, only that 5. Okay.
Much obliged, my Lord.
Disposed of.
For admission, item numbers 14 to 16.
Yes.
Your Lordship, that judgment is Kushal Kumar Agarwal versus Directorate of Enforcement.
Give the citation.
2025 SCC Online, SC 1221.
SC 1221. Okay.
Here also, there also my that ED counsel, Mr. Joy Hussain, was appearing. A similar matter pending in Delhi High Court.
Okay.
My Lord, before I go into this matter, I would like
There are 2.
3 in fact. 3.
Oh, there are 3.
3.
Inalo Jhimoni.
Yeah,
Who
that's
is
me.
the-
That's me.
Okay.
That's
he is
me.
the judicial officer.
He was the, at that point of time, principal district and session judge, Dimapur. My lord will kindly come. I will give a chronology of events.
You are ready with the matter? Case diary is there?
Yes, my lord.
I've received.
I don't know, kindly note these dates.
Huh. Yes. This is AB, so make it short.
I will make it short.
Yes.
On 1/10/2021,
Wait, 1/10/2021. Yeah.
yes,
Yes.
till 2nd of October 2024, I was discharging the office of, I was occupying the office of Principal District and Session Judge, Dimapur, Nagaland. Now, so on 3rd October 2024, I was transferred to District of Mon as District and Session Judge. On 7/10/2024, I handed over the charge of my office to the Chief Judicial Magistrate. Now, your Lordship will kindly come to the Assam Financial Rule. I have annexed that particular thing. Your Lordship will kindly come to page. What is the page numbers?
You have annexed it with
Yes,
the
yes, I have annexed in my lord. Annex a P5.
P5. Yeah, yes, the last one.
Yes, yes, yes.
Certificate of transfer of charge.
Yes. Kindly see, it is under the Assam Schedule 3, form number 81.
Uh-huh.
Your Lordship
This
will,
is 3rd October 24 notification.
pardon, my lord?
Oh.
No, 7th October. 3rd October is a transfer order.
Okay.
3rd October, your Lordship will find a transfer order. I am at serial number, notification number 4. Sri Inalo Jimomi, Principal District.
Is transferred and posted as so and so.
So and so. Why Sri Mati so and so?
He will hand over
He will have
charge.
charged of his court and office to CGM Dimapur and proceed to join his new assignment immediately. Now, accordingly, I handed over my charge on 7th October. That is the last page.
Okay, 7th October. Okay.
7th October.
Relieving officer.
Relieving officer is the CGM. Because now, your Lordship, this will find this particular transfer of charge office was being marked to 11 individuals. Most important is that register vigilance is there, serial number 3. Serial number 4, registered Gauhati High Court, Kohima bench. 5th, the Accountant General, Nagaland, Kohima. Private Secretary, the Protocol Judge. Deputy Commissioner, Superintendent of Police. Senior Treasury Officer. CGM, Dimapur. So let us keep this thing. Now, kindly see Assam Financial Rules, Rule 145. Why I am reading it? Because this is what I have argued in the Honorable Supreme Court also. Same thing. Sir, please.
Assam financial rules.
Yes, my lord.
Applicable here.
Yes.
Adopted.
Nagaland does not have their own financial rule.
Adopted.
Yes.
Okay.
Section Rule 145, my lord. Transfer of office. Every transfer of a charge of a gazetted government servant should be reported by post on the same day to the Comptroller, Accountant General. For transfer of charge, the following points should be observed. Number 1, the cash book or impressed account should be closed on the date of transfer and a note recorded in it over the signature of both the relieved and relieving officers, showing the cash and impressed balance and the number of unused checks, if any, made over and received in transfer by them respectively. 2, the relieving officer in reporting that the transfer has been completed should bring to notice anything irregular or objectionable in the conduct of business that may have come officially to his notice. That is most important. He should examine the accounts, count the cash, inspect the stores, count weight and measure certain selected articles in order to treat the accuracy of the returns. He should also describe the state of the records. Now, my lord will kindly appreciate one thing. Like there are many seized properties are there in the court premises. Seized properties have been marked as exhibit and all. So that register has also to be there. So that the CGM will take that, yes, these are the things. Because there may be some firearms, there may be some contrabands. Otherwise, Malkhana is there. But court has also got their own Malkhana section. And that has to be taken care of. Now, in case of any sudden, casually occurring or any...
Oh, yes.
Yes. 3. In the case of any sudden, casually occurring or any emergent necessity arising for an officer to quit his charge, the next senior officer of the department present will take charge. When the person who takes charge is not a gazetted officer, he must at once report the circumstances to his nearest departmental superior and obtain orders as to cash in hand. But cash in hand, your lordship, that procedure has to be followed. Same procedure 1 and 2. Now, a note should be recorded in the charge certificate showing the number of copies of the Scripper Code of the currency department handed over to the relieving officer on the occasion of transfer of charge by treasury of sub-treasury officers. That is with respect to treasury guys, treasury person. So what I am saying is that...
Is that those are entered in the register?
Yes.
And nobody had objected to anything?
Nobody.
And he went and joined?
I went down. Now your lordship will see. Why I am... In my bail petition, normally your lordship, we just concern ourselves with the FIR. But here, I have to bring my facts because I was a serving judicial officer. I am saying because the inquiry which has been initiated against me for departmental proceeding, that was done under a particular rule of Nagaland Discipline Appeal Rule, 1967. Now, as we all know that when a departmental proceeding is drawn, then inquiry officer has been appointed, and after the inquiry, the due process, a punishment will be imposed, whether it will be a major or a minor. That is. But under no stress of imagination, when a departmental proceeding is pending, you cannot give a compulsory retirement, because compulsory retirement is not a punishment. As per the Petitioner.
Only when deadwood and all those, right?
Yes. But I was given a compulsory retirement under the Nagaland Judicial Service Rule.
But it is a punishment also under some...
Yes, my lord. That is what, and exactly it has been challenged now. It is pending. And when we went to the Supreme Court, Honorable Supreme Court, Supreme Court asked us one thing, that, okay, the main matter is pending. Now, how did the inquiry officer has been appointed? Then we told that we have been taken aback on surprise on the day the motion hearing was done. The standing counsel for the Gauhati High Court said that as far as Nagaland is concerned, we are following the Central Civil Service Pension Rule 2021. So as per that rule 8.2, a proceeding which has been initiated prior to the retirement, it is deemed to continue until as funding is there. So I told the Supreme Court, we argued in the Supreme Court that...
But then I've seen the High Court's order,
yes,
where it is said that once the articles of charges are given, then it starts. So retirement, he has not retired till then.
No, that is a very different thing. Once I was on a suspension, first suspension, so cause notice and everything was been done. So proceeding has already started. There is no doubt. Now, on the day, 27th of March 2025, an order comes that Inalo Jimomi, your suspension order of 4th December has been revoked. You are to assume charge of the office of District and Session Judge Mon. This order will come into effect from 28th March 2025 afternoon AM. That is 12, after 12. Next order comes on 28th March 2025. You, Inalu Jimobi, District and Session Judge, will hand over the charge to such and such. And you have been compulsorily retired. That earlier order. 27 compulsory retirement, but that will be effective from 28th afternoon. After I hand over my charge to the officer.
No, you were given suspension order, then they revoked it. And you were directed to join Mon.
Join Mon and
afternoon
and hand over my charge and say that you are now compulsorily retired.
Same order.
Same order.
Revoked suspension and given compulsory retirement.
Exactly. So when we went to the Supreme Court, we said this thing and the pension rule was there. Then the Honorable Supreme Court said, no, but then in that case it has to be reviewed. When the bench was of the view that it has to be reviewed, then we immediately took the liberty and a review petition is in the process. Now, that day, on 26th May, when that order was passed by our former Chief Justice, On that very day, I came to know an FIR has been lodged against me.
The judgment means the present judgment where it is said.
A compulsory retirement. Yes.
So you were. Acha, we will confine ourselves to the FIR whether it makes out a case for bail.
Yes.
Problem. What you have said on the other day is that he had already made an application to look into this cash being deposited in account. And then after that he was charged of misappropriation.
Oh, this is the confidential papers. Kindly.
It's okay. It's there.
Yeah. So I was the person. When I was the Chief Judicial Magistrate at Kohima, I flagged the issue that as per the rules, High Court rules, Gauhati High Court rules and all, the amounts of money which has been collected, those are not been deposited in the treasury.
Because there is no rule, there is no.
There is a rule because High Court rule is there.
High Court rules, but it is not followed.
Not followed. Now the problem is what? The problem is what is that? Suppose a person, a district and session judge in any district, he not only discharge the office of a session judge, but also as a district judge with respect to civil, MACT, industrial tribunals, multiple offices. So for that person, one person, sitting on multiple jurisdictions, he cannot look after the accounts because accounts are being looked after by a particular official. Daftari is there who will coordinate with the accounts.
No, judge is not expected to take money. He will not even take
He will
the
not
cash.
take the money. How can he take the money, my lord?
What is the rule? Like whenever a person files a bail, furnishes a bond, then the money is deposited where?
My lord, as far as the standard operating procedure, normally in all the jurisdictions, you pass an order, we will say that you get by two sureties of like amount, that is 50,000, 30,000, whatever. Now that is a bail bond under 445 our old code. So what does the person do? He will bring the two sureties. The court will verify the sureties. That is the CGM. We will verify the sureties because at that time case has not been transferred. It is a pre-committal stage. Because session judge has passed the order, the CGM will verify. Then the bail bond amount. Either if he is a government servant, normally government servant, against his pay slip, it will be taken up. If he has got given a land record, that will be taken up. But if he doesn't have those things, he will come, he will deposit, he will make a FD, fixed deposit, in the name of the court. It will be given to the court master. He will verify it, and that will be endorsement will be given.
He will give the cash.
No, he will give a FD, cash transaction. FD.
Yes.
Cash transaction is not there. He will give the FD against that FD, against that particular deposit in a particular head under the treasury accounts, our whatever criminal laws. That amount will be deposited in the state exchequer, from the treasury. So what happens is that the interest which has been, that is how one source of revenue. The interest which will be accumulated, that will be the property of the government. So tomorrow I got acquitted, bail bond and security discharged. So that amount I will go to the court, sir, this is my thing. Then automatically the court will pass the order, you got it from the treasury. That is the normal process. Now what is happening in Nagaland is there, I was shocked. You pass a bail order, the amount is collected. How it is collected? The amount will be brought to the account officer, bench assistant. He will be given, he will count the money and he will make the entry and he will give to the daftari. One person is the daftari. Daftari will collect the money and he will go and deposit in the particular bank account.
There is a special account for that.
Some are saying there is a special account, some are saying it is the judge's private account. Very disturbing. So that is why because my lord will appreciate this thing. When a particular thing of these judicial officers are involved, it is not only to that particular office, it is to the integrity of the entire system. Entire system. So the thing is that, of course, a thorough investigation is required. Of course, a thorough investigation is required. Because it's ultimately a fate. I am an officer, I am still an officer, I am challenging my proceedings in my service matter, that's a different thing. But I am an officer. Because it is casted not only on my integrity, but on the entire system. And I was the person who flagged it. Now your lordship will appreciate. Who is the complainant? He is a district and session judge, Dimapur.
And who is the complainant?
Yes, my lord.
But under High Court's direction.
No, my lord, that is also very interesting.
No, as directed by the Gauhati High Court.
Yes. Your lordship will kindly find. Where is it?
Page 28 of your petition.
Yes, my lord. Kindly come to annexer P4 first.
P4.
P4.
P4 is at page?
P4, 34.
Huh.
The Lordship will see, this is the form for the certified copy. Huh? FIR copy, I asked. Cash copy of bail register, which has been alleged against me, and the letter from High Court.
Cash bail register, the register where the
Where the entries were being made.
letter from High Court.
Yes,
Okay.
letter from High Court. Because I must know.
Yeah.
So what happened? The CGM gave me the FIR copy
Acha.
and said that rest documents we cannot give you. So once we got the protection from the High Court or Supreme Court, we apprised this Honorable Court. Court number 1 was presiding that matter. Then we apprised this thing that this is the condition. How can I even contest my matter? Then the court directed, this Honorable Court directed to the CGM that you please provide this document. Then accordingly those were provided. Now, these documents are there.
Where? Page?
It has not been annexed because at that time I did not have that copy.
Acha, not required. I mean the cash register and the High Court's order. It's okay.
You should have made it. No? Don't become like a clerk.
Acha.
Do you have the soft copy? Show me the soft copy. There was a letter dated 24 May 2025.
Yeah, I've seen this.
Yes.
This is the from the Registrar Vigilance to lodge an FIR.
Yes.
Thereafter, Registrar also said that I have lodged an FIR.
This is against the standing instruction of the Gauhati High Court. How? Your Lordship will kindly come to notification dated 27, Alexa P3.
This is different and this is different. This is okay. This is a general notification.
Yes, my lord. How the proceeding has to be carried out against the complaint you receive against the judge. This notification suppresses all other notifications. It says a committee has to verify it. Committee has to verify.
Complaint making allegations against subordinate judiciary should be entered in and no action should be taken unless it is accompanied by duly. Okay. Affidavit. If action on such complaint meeting, the above requirement is deemed necessary, authenticity of the should be duly ascertained and further steps should be taken only after satisfaction. Okay.
So, and if these two letters is a communication from the Registrar Kohima to the Registrar Vigilance. Registrar Kohima and Registrar Vigilance, and a communication between the Session Judge and the Registrar Kohima that you lodge an FIR. Why? Because at that time I was already been thrown off from the service. I was already been prejudged that I am the man. So instead of this notification, the standing operating procedure would have been, you receive the complaint from the Kohima, the authority, they should have placed it before the committee. That is our presided by the JAD. They will take a call that yes, you have to do it. Now what happened is that these two persons, Registrar Vigilance and Registrar Kohima, and the Session Judge, they did it.
And what you mean to say, it is not an instruction from the High Court?
No, it cannot be.
Nacha.
Because as per the notification, it has to come from the High Court. And High Court does not mean, registry does not mean High Court. High Court, registry is a part of the High Court.
Okay, then?
Then, your Lordship will kindly see. The entries which have been made.
Yeah, in the register.
Register.
Now you just show me what is there.
Yes, your Lordship. How did the, I was also trying to calculate what they have flagged certain things. But what is this? What does it mean? That amount was missing from the account of the court or it was missing from the almirah of the court?
Things are not clear.
Not clear. And most important thing, and most seriously most important thing is that,
No, as far as what I'm thinking is, as far as the judge is concerned, why would you flag if he had the intention to borrow the money? In fact, what I'm thinking is, as far as the judge is concerned, I will allow bail. As far as the other two persons who were responsible, who were in the job of taking the money, in that case,
my lord, in fact, I must say, it very seriously, let it be recorded. The CGM must be inquired.
this is a bail jurisdiction that you.
My lord,
make
no,
a-
no, that is one thing. Kindly see this order, passed by this present session judge. Passed by this present session judge. He happens to be the presenting officer in the pending judicial inquiry. This gentleman passes an order in a one CBI matter, saying that since, kindly see the operating portion, my lord. Kindly see the operating portion. Why I am taking this order for reference, take a judicial note under section 57 of the Evidence Act. Why? This judicial officer, session judge, present session judge, he never applied his mind, not even in my case, and to demonstrate that, kindly peruse the order.
This is in respect of what?
Another matter, look at this order.
Notary.
Yes, because the above I have considered a provision of law pointed by the learned counsel for the petitioner. The same is reproduced as follows. He refers the particular section of the Notaries Act. When a statute expressly bars taking cognizance, then implicating the present petitioner who is a notary in the instant case does not arise. What is perverse finding? Cognizance is a different thing. Investigation is a different thing. So what I am trying to demonstrate is that this gentleman at present session judge, he did not apply his judicious mind, fair mind, even in my case, and that can be demonstrated by this particular order.
He is the complainant.
He is the complainant. And my lord, look at my condition. I'll be prosecuted by the CGM, and the complainant is the session judge. Of course, I am thinking we might have to ask for the transfer of the matter.
Okay, what does your diary show? Case diary?
You'll also mechanically see the CD, my lord.
You say
Yeah, like
whatever
I
is
have
there.
extra
You
copy, my
flagged
lord.
it.
Yes.
Who is Lealo Cut?
Lealo Cut, I believe.
Accused number 2.
Accused number. My friend is even.
Oh, you are there for.
Yes, my lord.
Accused number 2 was handling the cash, right? He was accused number.
Deposit the amount.
He?
He will deposit the amount in the bank.
Oh, he was the person who goes and deposits.
Yes.
And the other one?
Other one, he will receive the amount.
He will receive the amount before depositing it in the bank. So the third one will receive the amount like courtmaster and all.
Yes.
Then he will give it to the other one who will go and deposit in the bank.
Yes.
So at least these two handles the cash. But as far as the judge is concerned, I don't think so. Because
Countersigned by the judge.
he should not be here. In fact, judge I will allow, but then the other two, no.
If I may be allowed to.
Acha, let me pass the order on in respect of the first matter, then I'll go to 2 and 3. Leolo Kat is the accused.
Yes,
Show me
my
some evidence of the independent witness. Somebody.
My lord, so far the independent witness, their statement has not been recorded, my lord.
No independent
Yes,
witness.
my lord.
Only accused statements are there.
Yes, my lord, here accused number 1 is the present petitioner. His statement has been recorded. And the respondent number, that accused number 2 and 3, their statement also recorded. And thereafter some advocates.
Their statements are recorded. This
Yes,
is
ma'am.
AB or BA?
AB.
my lord.
After as I was protected, I went for cooperation. I went before the IO.
Protected by what?
Protected by the Honorable Supreme Court's order.
Oh yes, he should have been given by.
Yes.
interim
When you
bail.
have, yes.
Oh yes, sir.
And thereafter, my lord, some advocates were examined and their statement has been recorded. And
Show me those advocate statements.
my lord, Lordship, may kindly see the page 22 to 27.
of the city.
Yes, my lord.
22.
Notice was issued on 7/7/2025, and thereafter, page number 23 is the.
Michael.
Yes.
He is an advocate.
Yes, my lord.
Okay, wait.
And,
I heard that the court of so and so granted bail on execution of bail bond as per the bail, the cash surety of 10,000. 10,001 retired BSF personal deposed before one court employee, namely Amram.
Yes.
Amram is an accused?
Yes, he's the accused.
Amram and one court employee. So the money was paid, deposited to Amram. And accordingly, the accused was released. That on so and so, I was heard in the principal seat, principal district, and execution as per 15,000 or low were handed a cash over to Mr. Amram. So all Amram. Then he is another advocate.
Yes, my lord.
So everyone will see, I mean, advocates will only see whoever they pay the money.
Yes, my lord.
Rest part they will not
Yes.
see. Cash amount was given to Amram. So they have seen only Amram. Mr. Amram. Okay.
And thereafter, my lord, notice was issued to the bank manager to submit the details transaction of the bank. So it was issued on 14/7/2025, and the details has been received.
Yes. What does he say?
And after that, the statement has not been recorded, my lord.
His statement is not recorded.
Yes, my lord.
He is the bank
Why-
official.
Yes, my lord. Page number 29, it says that details in regard to bank number so and so received from the branch manager.
So in this account, money is being deposited.
Yes, my lord. Yes, my lord.
And the money is missing from there.
I don't know.
Oh, acha. Money is missing from there.
My lord, the details has not been given, my lord.
That is what the investigation they are doing.
No, that will be the money has to be
Yes.
missing. Otherwise, what charge?
Yes, my lord. Now the
Show me the FIR. What FIR?
FIR, your lordship will find at Annex P1.
page number 1, my
As
lord.
directed by so and so, would like to inform you, esteem that sum of so and so was missing.
Yes.
Yes,
14,35,000 was missing
Yes.
in respect of the cash bill deposited in connection with so and so. Upon verification of the record, the missing cash bail pertains to 29 GR cases. That is the list that you have
Yes,
given,
yes,
right?
yes.
Which was found entered in the cash bail register in the year 2020. Upon verification, just observe, entry was inserted between the gap. What is gap?
What he wants to make? For example, entry number 1, so and so, entry number 2, so and so. So in between the
it's a gap.
they try to overread it.
Upon verification, it is observed the entry was inserted between the gap of other entries showing deposit of the cash bill amount without making actual deposits. So actual deposit was not made, but although in the gap it is written.
Yes. Now question arises is, my lord, is that the investigation which have to, as he is fairly submitting, the investigation has to find out the corresponding amount which has been deposited as alleged in the record. That has to be seen from the concerned bank, but because there will be a deposit slip. And the account which he is referring, I don't know about the case diary, the account belongs to whom? Which office?
Those are not there, no?
Yes,
not there.
my lord. Now the details of the bank account has been received, and that investigation detailed report has not been recorded, my lord. So now they are scrutinizing the documents, my lord. So it is in the investigation. It is in the investigation stage, my lord.
As far as the judge is concerned, I am allowing the bail. Okay. Heard Mr. S. Boragohai?
Borgohain, my lord.
Huh?
Borgohain.
Borgohai. Borgohai for the petitioner and Mr. So-and-so, the learned PP
Yes,
for the state of Nagaland. This is an application for bail. In connection bail, this is an application under section 482 of the BNSS, praying for anticipatory bail in connection with the West PS case number 40 of 2025, registered under section 316 subsection 4, subsection 5, slash 337, slash 3, subsection 5 of the BNS 2023. The case of the petitioner is that an FIR was lodged against him as well as 2 others, alleging that an amount of rupees 14,35,000 was found to be missing in respect of cash bail deposited by the accused, by different accused persons in connection with pending criminal cases. The petitioner is the principal district and session judge.
At that point of time,
At that point.
principal district and session judge, Dimapur.
At the relevant point of time, the petitioner was principal district and session judge, Dimapur. The FIR also reveals that a verification of the record was done, and it was found that the cash register pertaining to 29 GR cases it was found that that upon, what did I say? Upon verification of record. No, before. It was also the case of petitioner Nikki. Oh, it was found that entries were made between the gaps of other entries in the cash register showing deposit of cash and bail amount, but actual deposits were not made and simply entries were there. In the said FIR, 3 persons were accused of committing the offence, one being the petitioner. Was alleged to have committed. Okay. Mr. S. Borgohain, appearing for the petitioner, states that the petitioner on an earlier occasion had intimated the Chief Judicial Magistrate, right? Chief Judicial Magistrate as to the issue of depositing the cash bail, depositing the cash received in cases of bail.
In the year 2013, my lord.
In the, okay. What did I say? He has intimated the CJM about the cash.
No, in protocol just, my lord.
Not CJM.
No, I was CJM at that point of time. My lord, can you see this?
The petitioner, while working as a CJM, had intimated the portfolio judge, okay, of the Gauhati High Court for the state of Nagaland about the issue of depositing the cash received in bail matters in the account of a bank, account in a bank. I'll not go through the entire thing of the bank. It is the normal procedure and under the High Court rules that the cash received in respect of the bails should be deposited in the treasury
Under the respective heads, madam.
under the respective head of account, no?
Yes.
Head of account.
Heads of account.
However, in the state of Nagaland, the said procedure is not followed and the cash received on bails are deposited in an account maintained in a bank. What happened to this?
My lord,
Nothing.
I was being told that the concerned judicial officer was being summoned by the portfolio judge. At that time, the Chief Justice was A.K. Goyal. Loku. Then it was been severely reprimanded that next time if it follows, consequential action. With that warning, it was been kept.
He also submits that in view of the said complaint, the necessary directions were passed, and in non-compliance of the same, actions were also directed to be taken. However, the allegation, later, the issue for which the petitioner had raised has raised objections. The petitioner was himself entangled in the issue at hand. A disciplinary, he was
Compulsorily retired.
No. First of all, there were inquiry.
My lord,
A complaint was filed.
No complaint was filed.
Achha.
No complaint was filed.
Achha.
I passed 2 orders. In my judicial capacity, I passed 2 orders. Against those 2 orders, the Register Vigilance found that it was a grave misconduct. On my judicial orders.
Okay, you write that the petitioner was not the petitioner. An inquiry. Inquiry was conducted. Yes.
Preliminary inquiry, but it was during the inquiry pending. I was being retired on 27 March 2025.
An inquiry was conducted against the petitioner, and during the inquiry, the petitioner was suspended and was transferred to the transferred as an additional district and session judge, Mon.
District and session judge.
District and session judge. District and session judge.
District and session judge.
Session judge Mon. And by the same order, the petitioner was compulsorily retired.
Order dated 27 March 2025.
It's compulsorily retired. The petitioner had challenged which the petitioner has challenged before the respective courts, and the matter is pending. In the meantime, Mr. S. Borgohain submits that during the inquiry, an FIR was lodged against him, which was stated above. He submits that the petitioner has no role in taking the cash which is submitted by the bailers. He only endorses in the register. As such, he has no connection with the same. Further, he also states that there is nothing on record as to in which account the cash is deposited, and that it is not his account. And missing of the cash from the said, and he has no connection with the missing of the cash from the said account, if any. As such, Mr. S. Borgohain,
That 145 rule?
Yes. He has also placed Rule 145 of the
Assam Financial Rules.
Assam Financial Rules. Which year? which is adopted in the state of Nagaland,
Nagaland.
and which provides that
The search relieving officer and the person giving relief has to jointly endorse the accounts.
Acha, you have placed subsection 1, right?
Yes.
Which provides that that while the cash book or the impressed account is closed, both the relieving officer and the relieved officer puts a note on it. Showing the cash and the impressed balances and the number of unused checks.
And if there is any discrepancy, they has to mark it, my lord.
Where is that?
My lord, it is in rule 3, rule 2.
Acha, I'm going to one by one. The relieving officer in reporting to the transfer has been covered, and it also provides that when a relieving officer, no, not when, that the relieving officer on transfer being completed should bring into notice anything which is found irregular or objectionable in the conduct of business, in the conduct of the business. No, 3 will not come. This is in exigencies.
Two.
Oh, yes. And then it is also provided that the relieving officer should examine the accounts, count the cash, inspect the stores, etc., in order to see the accuracy of the returns. And that he should also describe the state of the records. Mr. Burago has stated that there has been no stipulation on the said accounts, which demonstrated that there was any irregularity on the part of the petitioner.
And the fourth was, my lord, the non-compliance of the standing instruction passed by the Honorable High Court of 27 March 2017.
Oh yes. He also states, and he has annexed in his bail application, the
27 March.
Applications, the guidelines to be followed when complaints are received against the members of subordinate judiciary, wherein it is stated that if a complaint is received, the same should be accompanied by a duly sworn affidavit, and the same should be examined by a committee concerned. By the competent authority, not committee.
The competent authority.
Yes.
Competent authority.
You say further steps should be, and that, and that the complaint should be duly ascertained. The authenticity of the complaint. The authenticity of the complaint should be duly ascertained, and steps to be taken only after the satisfaction of the competent authority. Mr. Borgohain submits that none of this was done, and only on a complaint made by the registrar of the High Court.
My lord, under the direction of the Registrar Kohima, the Principal District and Session Judge Dimapur lost the FIR.
No, there was a letter by the, in that thing you have.
No, it is, first is 24 May, from Roman Bora Registrar Vigilance. I have given that copy, my lord.
You had given the.
Yes, I have given a certificate.
Things that you have received, right?
Yes.
From the RTI?
Yes, my lord.
Yes. And only on the letter only on the letter of Registrar Vigilance Gauhati High Court addressed to the Registrar Gauhati High Court Kohima bench, an FIR was lodged by the district and session judge.
As directed by Registrar Kohima, my lord.
District and session judge Dimapur, Nagaland, on the direction given by the Registrar Gauhati High Court Kohima bench. This is all your submission?
No, this is
Mr. So-and-so, appearing for the state of Nagaland, by relying upon the case diary of the case, states that
My lord, petitioner statement has been recorded on 17/6/2025.
States that the state, no, what about the allegations against him?
My lord, as per the FIR, it is very clear that the allegation is very serious in nature.
States that the allegations made in the FIR are serious in nature and there are materials against the petitioner in the case diary.
And
Now, whether it is Abram or this Aram
yes,
or Liato Kat has stated something about the petitioner.
no, my lord.
He has placed the statements of the advocates who stated that the money were given to another accused who is arraigned in the FIR.
And my lord, the case is under investigation. So
He also states that the case is under investigation, and although the statements of the accused was recorded by the IO, yet there may be more statement. There may be requirement of more statements to be recorded
yes, ma'am.
of the petitioner.
So at this stage, prayer should not be granted.
As such, at this stage, he prays that no bail should be
Yes, ma'am.
afforded to the petitioner.
Yes, ma'am.
Heard counsels for both the parties. It is noticed that the petitioner had in the year where is that PK Saikya sir, sorry? Had it's noticed. Yes. Oh, no. Oh, yeah. Notice that the petitioner in the year 2013 had made a representation to the portfolio judge of the state of Nagaland This is on different respects. The cash amount that was deposited to his predecessor was found missing.
Yes.
And then there was charges that he along with her had misappropriated.
Yes.
And then he
gave the details of that GR case because that amounts were deposited in the same fashion. 1,60,000, 1,55,000. Kindly come to annexure A, my lord.
No, it's okay, page number 3, where he had stated that it had come to his knowledge that the cash surety deposited during the tenure of his predecessor was handed over to him and that he had misappropriated such money. And that it was alleged that he and his predecessor had connived and misappropriated the money. He as such placed it before the learned portfolio judge to look into the issue, since that has created a serious doubt in his integrity. It is in the
My lord, this particular representation was forwarded to the Register of Vigilance also.
It is in the findings of the court that had he been involved in the said offence, he would not have written the same to the Honorable Portfolio Judge,
And the Register of Vigilance, my lord.
as well as the Register of Vigilance to whom he had forwarded the copy. Further, it is a known fact that he being the principal district and session judge, he being the CJM that time.
At that time, he was CGM, Kohima.
No, when the FIR was lodged in respect of the offence.
It was, at that time, this FIR was registered after I was retired.
No. I mean, the issues were missing in respect of so and so. That time what was he?
At that time, I was CGM, Kohima.
District and session judge.
No, madam.
During the relevant period, during the following are the officer and staff who were responsible in handling.
That time I was district and session Dimapur.
Yes, and that when he was working as a district and session judge in the year 2025.
No, ma'am, not 25.
Acha, before that, what did I say? No, before this application. Yes, he would not have letter. After that, to write. It is also noticed that an inquiry was conducted against him and the same is pending disposal by the authority concerned. And that he was under compulsory retirement as has been stated above. The instant FIR was lodged after he was sent on compulsory retirement.
Yes.
After he was sent on compulsory retirement, alleging that he was also involved in the handling of cash bail records during the relevant period.
I won't say that one, but if His Lordship see the FIR, the relevant period is also blank in the FIR column.
During the relevant period. It is known that the judge is not, the judge does not handle the cash which is given by the bailers in respect of the bail cases. He puts his signature in the register, showing that the cash has been paid in respect of the bail orders. The cash is thereafter deposited in the account as is the procedure followed in the state of Nagaland. In view of the same, this court is of the view that the petitioner may be released, may be enlarged on bail in view of the arrest made. What did you say in
My lord, this Supreme Court's order, no, my lord.
Where is
Your
it?
lordship, kindly see this order. Just, I wanted to clear this one. Accordingly, petitioner is granted PRS bail subject to cooperation and investigation till case number so and so is finally decided by the High Court.
Acha, before that, in view of the, give me that, maybe it's here, but I'm not
My lord,
finding.
I have placed last time.
Ah, yeah, it's here. Further, in view of the,
That order will be made absolute, my lord.
you have to place, when we wrote his submissions, you place the last line. Huh? Mr. Borgohain has also placed the order of the Honorable Supreme Court, dated is what? Dated 29/5/2025?
Yes.
No.
No, it is not.
Final judgment. Oh, 16/6/25. By order dated 16/6/25, had granted pre-arrest bail, interim, no?
Yes, my lord. Till your lordship decides the matter.
Granted pre-arrest bail till the matter is decided by the High Court. Subject to cooperating with the investigation. In pursuance to the same, the petitioner had given his statement before the investigating officer. That you write in his submission. Then go down. Further, in view of the order dated 16/6/2025, the Honorable Supreme Court had granted pre-arrest bail subject to cooperating with the investigation till the bail application is finally decided by the High Court. Pursuant thereto, the petitioner was examined and he had given statement before the investigating officer. As such, this court grants the petitioner the pre-arrest bail in the event of arrest being made by the
authority?
By the authority concerned.
He will be released on a payment of?
On furnishing of bail bond of rupees.
I am a compulsory retirement and no money was at this point. 10,000, my lord.
No, 20,000. On furnishing of a bail bond of 20,000. He was a judge, no?
Yes, my lord.
With two sureties of the like amount. One being not required.
No,
two
not required,
sureties of the like amount to the satisfaction of the CJM.
My lord, can I?
Subject to the following conditions. He will cooperate.
I am cooperating, my lord. I will cooperate.
Okay.
I am cooperating, my lord.
Yes, again. He will
Yes.
cooperate with the investigation and would appear as and when called for.
Yes, ma'am.
He will not temper with the evidence or influence the witnesses, whoever is connected with the case. He will not leave the jurisdiction of the.
My lord, that is an issue.
Without the leave.
My lord, that is the issue, my lord. Because now these 2-3 matters are of these similar issues in respect to his service matter. He has to travel to Gauhati, my lord. So
Then you take leave.
No, my lord, yes.
I will inform the IO and go.
Yes, my lord.
I will inform the IO.
Without the leave of the investigation officer.
Without
I should not
informing.
be-
Okay, without informing. As a judge, we should have.
Why should I run away?
No, my
He
lord.
will not.
My lord, if he is ready to cooperate the investigation.
I'm cooperating.
No, he will inform and go.
Yes, my lord.
I'm cooperating.
So third condition, he will, if he had to go to some other place out of the jurisdiction of the CJM, Dimapur.
My lord, Dimapur.
CJM what?
Dimapur.
Yes.
He has to inform the respective IO, the concerned IO.
My lord.
Inform the concerned IO.
Yes.
Okay,
Yes.
that's all.
My lord,
The petition is this interim order is made absolute.
My lord, this interim order.
Interim order dated so and so made absolute. dated 16/6/2025 is made absolute. Petition is disposed of.
Madam, those papers can I get it back?
What papers? There are so many papers here.
Madam, yes, madam, that certified copy and that inquiry.
This is
I was
to
thinking
him.
if your
This is to
lordship
him.
may look into in one thing on a very serious issue that this particular.
No, my lord, in this
if your
the
lordship,
next case, I'm referring this city,
okay.
same city.
Your lordship, as far as the other two co-accused are concerned, with my learned friend will argue, the lordship may exercise the inherent power to go as per the High Court rules, deposit of bail amount. Because today it happened with me, tomorrow it may happen with someone else. Very serious issue, my lord.
No, that has to be actually, whether in this bail order I will incorporate, but that will serve no purpose.
Yes,
Because
my
the
lord.
lordship can issue under 482, suo motu the court can take. The lordship can take up with court number-
Administrative side.
administrative side.
Okay, that I will do. Acha, what is this? This is an order. I is disposed of. Oh, do you have given
That
a
I was
similar
showing
order? And give it to him. And wait. This one. This is there. And this is there. The petition is disposed of, right? Okay. This is gone.
Obliged.
Aru?
Much obliged.
Yeah, this is over. 14 is over. 15? This is Amram.
Yes, yes.
Hey, the allegations are all against Amram.
Apparently, the police may call.
Yeah.
Lordship,
You bring all tough cases
I-
where I cannot give you any relief.
I bore on before
Morning
your
also I
lordship.
could not give you.
I bore on before your lordship. I'm coming before the Temple of Justice, and this has the discretion to.
What is this
the-
additional
What
affidavit?
has the discretion to? run
Yeah,
the-
of course. But
No,
in
having said that,
Ah.
Lordship, if I may be allowed to make submissions separately for the two applications, I'm representing both the other co-accused persons. As going by the registration, the accused Mr. Amrams comes as 17. Now, if I may be allowed to make very limited submission with regard to the role of both the accused persons. Now, Amrams.
oh, you are appearing for both Amram
Both.
and the other one is?
Yeah. The other co-accused person.
The other five?
AB number 18 of 25.
Yes. I'll just check out his name. Lialo Kat. Okay.
Besides other regular affairs in the state, in the court, my role as far as this case is concerned is I accept the cash surety which are being deposited by the concerned advocates or the clients, whoever comes. Now, there's a practice which the earlier senior counsel has already stated, the practice in the state of Nagaland. Now, my role is very limited to the extent that I receive and I hand over to the concerned person who takes care of the accounts, that is the other co-accused person. Now, my role is to accept it and hand it over, which is being deposited in the account maintained in the name of Principal District and Session Judge Dimapur. There's an account bearing account number 3041.
You are a staff of the court, right?
Yes, very much.
Both?
Both are regular staff of the court. That also shows that there's no chance of fleeing from justice. We are cooperating as of today and we are ready to cooperate within
You had
investigation.
given statements also?
I appeared on 28th of May as per the direction of this honorable court. On the day when this application was filed, I was given a direction to go
You-
and appear. No interim protection was given.
Acha, you did not go to Supreme Court, nothing?
I did not go. I was given a direction, liberty to appear before the
Where?
The first order, if I may be allowed to refer to 28/5/2025.
28/5?
2025.
Yes. There, you were given interim? No.
No interim was given. Subsequently, I was given interim on 9/6/2025. Subsequently, after appearing before the investigating agency. May I read it? This is dated 28/5/2025. This is.
Go down. The
Mr.
learned, however, on perusal of case record.
Yes.
Oh, which is not supported by FIR.
Yes.
Hey, you had not annexed the FIR yet?
Subsequently, I have filed an additional affidavit.
Oh, you did not get the FIR?
Yes. At that point of time, because I have to
Is directed to
Right before
furnish
this
FIR at true and so and so.
Yes.
I do not find fit to extend any interim protection. However, the petitioner is at liberty to approach the IO of the case and cooperate with the investigation. Acha. After this, you had gone and
Immediately,
given your
the very
statement.
next day, I appeared before the investigating agency on 28/5/2025.
29.5.
This
This order is
Yes,
28.5.
yes, yes, yes.
You went on 29.5
Yes,
without any interim protection.
without any interim protection,
Interim protection granted you later or what?
later
No. When?
on 7/6/2025. 7/6.
9.6.
9/6. My
9.6.
apologies. 9/6. Without interim protection, I appeared. That itself speaks about my involvement in the case.
One thing is there, Mr. PP. He, without an interim order, he went and he gave his statements. Right? He is cooperating. So why should we make him get arrested and then?
No, my lord, as per
He
the
has staff only.
yes, as per the statement recorded from the accused number 2 and the 3, and those advocate clearly says that they are also admitting. They are the one who have received the amount, and they are the one who has deposited the amount.
Deposited
So-
in the bank.
Yes,
Then
my
where
lord.
did the money go?
So now
So
the
maybe bank officials may also be involved.
now the transaction between the bank and the court, everything is done by the 2 accused. That is accused number 2 and the 3.
Maybe bank
So-
officials are involved. Right. Can be a fact. Show me their statement. What did they say?
So, my lord, your lordship, may kindly see this.
You had already given me once. I gave you back. Yes.
Page number 5. That is accused number 2.
Okay. Leato cut. I leave it so and so so and so. During the time, Sir Inalo, bail bond surety was collected by me from Amram, which was accordingly deposited in the SBI bank with proper receipt. During the time of, I used to submit fine money 1 to 2 times a month with the SBI Dimapur branch. It's a SBI branch.
Yes.
And but for the bail funds, but for the bail bond surety money which was submitted in SBI Rangapur branch, the limit was so and so per day daily. As the daily limit for so and so was, I used to collect so and so Amram, which takes me 4 days to deposit in the bank, and after depositing the money, which had another rupees is again collected from him after 4 days, since I did not feel it safe. I my cousin for a long time, and since only 50,000 could be a point, I used to collect rupees 2 lakh from every 4 days, and money deposited and record is maintained by me. From advocate and was kept in custody, collected so and so after every 4 rupees deposited in the bank. During a month, the bail bond entry register was in custody of so and so 2-3 weeks. Since he is not returning back the entry register to me, I asked Imran for the register, which was with so I said I have made entries in the register, and I for me if the I went through the entry, I came across it was not done by me.
Page number 2 is the statement of the accused number 3, my lord.
He said that there was some problem, and then he reported, right, to so and so. Longshi and Amram. Who is Longshi?
The present district session judge, Dimapur.
Present.
Yes.
Yes, my lord.
After this one.
Yes, yes.
My lord, the paragraph,
But
the last.
then, this one, he had admitted that you are for, no, I'm talking about Lialo cut. Lialo Kat had said,
My lord.
but see, in the middle of 2025, Mr. Amram has confessed before. Oh, Amram has confessed that extra entry in the register was done by him without my knowledge, but did not confess to taking the amount. The register that entries in the gap
Yes.
were made by Amram
Yes.
without the knowledge of Kat.
That-
Right.
without the
But he
knowledge
did
of
not
accused.
confess about taking money.
Yes.
Amram told Sir Longshi that since the entry in the register was made by him without Lakat's knowledge, he stated that he will refund the money. Why
Yes.
will he refund if he has not taken?
Yes.
Could be on the instruction of anyone.
Yeah, it can be by police also, you never know. But then, one thing, that amount was received by Amram.
Yes.
That was stated. What does Amram say? The amount of money to be mentioned in the behavior. I received the cash bail in cash. I used to hand over to Liako Kat. He refused to take amount. As he refused to take large amount of money, since he stated he does not have the space to keep large amount with him, only 50,000 on trust between us. I did not maintain any money handling, taking over register, and also did not maintain any money receipt register from the amounts received from the advocate. All the money received from the accused was kept with me for safekeeping. Bail bond is done by me as per Inalu, and he has given his signature. After the total amount was calculated and entered by so and so, I made the entry. Whenever I am in the office, the money is received only by me, but I don't have any knowledge on who receives the money during my absence. No, I mean, of course, money
So-
was received by him and deposited, but
Yes, my lord, and their statement has been collaborated by the other accused who have been examined, my lord. That advocate's statement.
they
There-
also said
yes,
they had
same
paid money to Amram.
To the Amram. So, my lord, here the case is
But
misappropriation of
whether
fund.
whether he has taken.
So here the case is in regard to misappropriation of fund. So since the statement is also very clear that they are the one who has handled the amount. So there is a prima facie that it is lies between the accused.
The investigation will go
So, my
on.
lord,
Let
so
them be on anticipatory bail.
Investigation.
Investigation will go on. They will cooperate.
Time should be given to the investigation to thoroughly, my lord. Sufficient time may be given to the investigation agency.
That is not before me. That they will do. It's only bail he is praying for. So he has gone and recorded his statement. They are staffs of the court. They will not flee away. Right. And then it will be seen who had misappropriated the money. Let them be on bail. Why again arrest him and put him behind bars? Anna.
My lord, may I appreciate, though I'm just a grateful employee, my service is required on daily basis because there are very limited staff. In fact, there are only two staff that handles this case receives and the visit by the other co-accused person. Our service is needed on daily basis. And I'm a regular employee of the court. Personal liberty is at stake.
My submission is the petitioner prayer should not be granted. Petitioner prayer should not be granted.
Bail.
I have an objection.
No, we will give conditions and then he will not leave and all. We'll only with the permission. Okay. And all that. Conditions will be there. What will be the purpose of arresting and keeping them inside? They have all statements were already recorded. And police will investigate, seize whatever is required. Must have seized only. When was the FIR lodged? 2000? 17-3, something, I forgot the date.
Yes, 25th of May 2025.
Not very long. Procedure is also not followed properly here. And see, he had said only 50,000 he can deposit in the bank because there is a limit.
Yes.
And so he used to keep, he doesn't take the money, entire money, he keeps it with Amram. Right, Lekato Kat says.
Yes.
Amram also says that yes, he keeps the money with me. And then I had also given some money to him. This is not for quashing, this is for bail. Let them pay on anticipatory bail.
I've paid my submission,
Oh,
so
okay,
I leave it to your lordship.
I'll write your
Yes, ma'am.
objections. Okay? There's no one. Same facts will follow. I think, oh no, there will be something different. I saw Dika here. Where did he go? The stenographer. This is an application under section 482 of the BNSS, praying for pre-arrest bail. This is an application filed by the petitioner. Okay. In connection with the West Police Station case number 0040 of 2025, under section 316 subsection 4 subsection 5 /3 subsection 5 of the BNSS 2023.
337, my lord.
Or 33/337, huh? After 316, 337/35 of the BNS. The first information report. We had given an additional affidavit. Yes. The first information report reveals that the petitioner was involved in missing of rupees 14,35,000 in respect of cash bail deposited by different accused persons in connection with pending criminal cases. Was allegedly found, huh? Was allegedly found, huh? The FIR further reveals that the records were verified, and upon verification, entries were found made between the gaps of other entries showing deposit of cash bail amount without, however, making actual deposits. The petitioner was alleged to have been involved in handling of the cash bail, and the FIR was registered against him. Mr. So-and-so, your name please? Muaz Amir, appearing for the petitioner, states that the petitioner was granted interim bail on 9/6. The petitioner was directed to cooperate with the investigation and to approach the IO of the case. No, write it the other way, huh? The petitioner was directed to approach the IO and to cooperate with the investigation by order dated 28/5/2025 by this court. And in compliance of the same, he approached the IO and he gave his statement in connection with the present case. On the next day itself, that is on 29/5/2025. In the beginning where we had written petitioner, no? You say who is the staff of the district and session judge? Who is the staff in the court of district and session judge? He had also stated that by a subsequent order dated 9/6/2025, the petitioner was released on interim bail. Interim bail, full stop. Mr. What is your other submission?
I'm cooperating and I'm ready to cooperate.
He as such states that the petitioner is cooperating with the investigation and as such he may be released on the pre-arrest bail. Mr. Zamir,
E. Tipapom.
your name is difficult to remember actually.
Tipapom.
Tipakhom.
Yes.
Tipakhom, the learned public prosecutor, submits that the submits and places the case diary and states that the case diary reveals that it was the petitioner, namely Amram S. Arkha, who had actually taken the money from the bailers in different bail applications.
Yes.
And the same was stated by the advocates whose statements were recorded, as well as by the petitioner himself. As such, he prays that the money which was received by the petitioner was found missing and that he is involved and no bail should be granted to the petitioner. I have heard the counsels. It is apparent from the records of the case that even without obtaining an interim bail order, the petitioner had gone and given his statement before the investigating officer. Full stop. He had cooperated with the investigation without any it is noticed that he had fully cooperated with the investigation, inasmuch as on the day when he was directed to approach the OC and give and cooperate with the investigation, the starting of the sentence perhaps is wrong. What? On the day I said, no? On the day, Choro, he has fully cooperated in the investigation. On 28 8 on which date?
29/5.
On
Order was 28/5.
28. On 28/5/2025, he approached the OC. That will remain the same. He approached, he was directed to approach the OC and cooperate with the investigation. And on the next day itself, he went and gave his statement to the OC, which is unusual for an accused person to do the same. He had further stated before the OC that he had received the money and that he had received the money, Amram, right?
Yes.
Yes, and he had received the money and he gave the money to the other co-accused for depositing the same in the bank. He had also stated that since only rupees 50,000 is accepted by the bank in a day, the other co-accused had requested him to keep the money and that he had handed over the remaining money which was kept with him to the other accused for no, don't write that. He has deposited, okay. What did I say? 50,000 is the money, right? He? He had? And that he hands over the remaining money to the other co-accused for depositing the same in the bank. Since the petitioner has cooperated with the investigating officer fully, this court is of the view that the petitioner may be released on pre-arrest bail in the event of his arrest on furnishing of a bail bond of rupees 20,000 with 2 local surety of the like amount to the satisfaction of the learned CJM with the following conditions. He will cooperate with the investigating agency and would appear as and when called for. He would not tamper with the evidence or influence the witnesses connected with the instant case, and he will not leave the jurisdiction of the CJM Dimapur without the leave of the said court. The petition is disposed of with the above directions. The other one also, same facts will be there, yes. Right? But only the difference is, wait, give me the other one.
Yes, that received the amount, so no entry was made in the registry.
Give the other one. You have given? Oh, yes, it's there.
Other one is who has deposited the amount.
Who has deposited the amount. If the two are given,
Yes.
why should he be left out? Right. He was also given interim bail, right?
Yes, by the
And
same
he was
order.
also given bail and he appeared, gave statement.
Yes, yes, yes. On the
Similar.
same day. Yes.
Similar.
Yes.
That will be all similar, I think. Then, okay, on seeing this, I will make the necessary correction. Same
Hello.
things will follow,
Yes.
even in it. Only that he used to deposit the
Yes.
money in the bank. And what did the case diary say? The last paragraph you write that where the statement of the accused I have written, there you write that I have to make the changes. Witnesses have not stated about this name.
Yes, yes.
Liato cut.
Only the accused
Only
number
Amram.
3. Yes, madam.
So that one I'll have to cut. You give me number, the order of the accused number 2, there I'll make the corrections. But one paragraph you write, he stated in his statement before the IO that he was the one who deposits the money in the bank and that since only 50,000 could be deposited in the bank in a particular day, he collects only some amount from the co-accused, that is Mr. Amram, and then deposits it in the bank. He stated that the money is collected by Amram and then he goes and deposits. He also stated that he deposited every amount in the bank after making proper entry in the register, and a copy of the bank deposit slip is maintained in the office. But there is a statement made by this one, a Katho, that Amram had returned back some money, 1,45,000, 14,35,000. Now you are saying that it is not your contention, right?
Yes, yes. Because I enter only whatever I receive from the co-accused. In fact, my role is very limited.
Okay, this is all. And then in view of the in view of this approaching the police and so will remain the same. Okay? Take. This is
Much
also
obliged.
20,000.
For orders, item number 17.
May I please, Your Lordship?
Yes, 17.
May I please,
Vakalat nama and AO not filed. Vakalat nama not filed by whom?
Respondent number 1.
One, respondent number 1. You are for respondent number 1?
No, I'm for respondent number 2, Your Lordship.
1, nobody is appearing.
I'm appearing for response number 1.
Oh, you are for respondent number 1?
Yes, I'm not filed.
Okay, State Council?
Yes, ma'am.
Oh, acha. The State Council, where is the requirement of vakalat nama? You are impleaded as respondent number 1?
Yes, madam. But since it is a content matter, so...
Oh, acha, this is a content matter?
Yes, madam.
Okay.
And my lord, I'm informed that this response number 1 has been transferred. Now new incumbent has...
Now you have to implead then?
Yes, madam.
So you will file an impleading application?
Yes, Lordship.
Okay. It is stated at the bar that respondent number 1 has been transferred and in his place, new incumbent has joined the office. As such, the petitioner the counsel appearing for the petitioner prays before this court that she may be allowed to file an impleading application in respect of the same. prayer is allowed. List the matter after 1 week. Okay, list the matter after 1 week. Oh, she is present for 2 and
For hearing, item numbers 19 to 20.
you'll do it. Yes.
Lordship, this matter relates to the petitioners. The petitioners are paying a pay scale, Your Lordship.
Achha.
So, Lordship, the government has already issued one notification. This covers my case, Your Lordship.
Achha. On the recommendation of Nagaland Workchairs Commission and in pursuance of the Cabinet's decision, all workchairs in all departments whose name have been fully verified by the district level register and receiving fixed pay shall be granted scale. This is a good step. There are so many cases
Yes,
now,
yes,
and there is no
scale of pay.
distinction. Fixed pay shall be granted scale of pay as per revision of so and so. Therefore, all departments having workchairs directed to okay, fine. So
in light of this, in terms of that, Your Lordship, I may be.
you are praying for scale pay only?
Yes, minimum scale of pay.
Achha. What is a prayer? Just let me see once. Here
number
counsel
5.
Mr. Imti Longzem appears.
Yes.
He is not there today. You are his junior.
Yes, Your Lordship.
Achha.
Page
We
5,
work
page
to,
5.
we practice together.
Yes,
Achha. Huh.
Page 5, Your Lordship.
Just show me your prayer.
At page 5.
Page 5, yes. Director has to pay this in terms of the ROP 210 and okay. I'll give a short order.
Yes, Your Lordship.
This is an application. Filed under Article 226 of the Constitution of India for a writ in the nature of mandamus. To pay the petitioner scale pay in terms of ROP 2010 and the ROP 2017 with arrears thereon. It is the case of the petitioner that the petitioner was appointed as a peon under the establishment of Deputy Inspector of Schools, New Land, NIULAND, Dimapur, with effect from 1/12/2007. While order dated 4/12/2007. The appointment of the petitioner was on contingency basis and was on a fixed monthly pay of rupees 3,500.
Initially, it was 1,500, further enhanced to.
Oh, yes.
3,500.
On 1,500, which was later enhanced to 3,500.
Lordship, it's actually 3,450, Lordship.
Yes, it's okay. 3,500. And that at present, he is drawing a consolidated salary of 3,450 per month. The petitioner also states that they were not allowed, or he was not allowed, the benefit of revision of pay, unlike his colleagues, which were serving on regular basis. He also states that in terms of the ROP 2010, a peon receives the scale of rupees 4,400 to rupees 17,200, and in terms of ROP of 2017, the scale pay was rupees 4,400 to rupees 17,200, with grade pay of 1,300. As such, he submits that he is entitled to receive the minimum pay in the scale of pay. He also states that the peons working on regular basis and on contingency basis works similarly, and the duties and responsibilities are all the same. And as such, same. But same. However, the pay is different. The contingency employee is paid a meager amount, and the regular employee is paid the scale pay. He as such states that there is no equal pay for equal work, in spite of the fact that they discharge similar duties and responsibilities. Because of the said discriminated treatment, the petitioner submitted a representation to the concerned authority, but the same had no positive response till date. During the hearing of the present petition, shall I write something on this affidavit?
No, Your Lordship, in that affidavit, actually what happened is that we have actually stated in our affidavit that previously there was no rules governing that the scale pay should be given to the fixed pay or the contingency employees. However, Your Lordship, after much contemplation, the government has come up with this.
Before this, you write, Ms. So-and-so states that you are for the government advocate?
Yes, Your Lordship.
Your name, please?
Livika, Your Lordship.
Okay, Livika, government advocate.
Yes, Your Lordship.
For the state of Nagaland, states that although she has, she has filed, not required, you cut this. Then during the hearing of the instant petition, the counsel appearing for the petitioner has placed one office memorandum dated 5th of March 2025, by which it is provided that all work charge and casual employees, by which it was provided that on recommendation of work charged and casual employees commission and in pursuant to the cabinet decision, all work charge employees in all departments would receive fixed pay, or who were receiving fixed pay would be granted scale of pay as per revision of pay ROP 2015 with effect from 1/4/2025.
Your Lordship, there is also a condition whose names has been duly verified by the district. That condition has to be done.
Yes. However, no. What I said that she had placed this, no? In the said office memorandum, however, it is stipulated that before granting scale pay, the names of the employees were to be verified by the district level verification committee. The said office
and registered in the
and registered in PIMS. The said office memorandum is quoted herein below. Just quote it from here to here. The counsel for the petitioner states that her case is covered by this office memorandum and the necessary orders may be passed in view of the said memo. Ms. So-and-so, the state advocate, submits that initially there was no rule governing, initially there was no rule which provided that the casual employees or the contingency employees were to be paid scale pay.
Fixed pay may also be included. The word fixed pay may also be included.
Who were receiving fixed pay. Casual employees who were receiving fixed pay were to be paid scale pay. She had placed a notification dated 16 December 2015 where the ROP rules were not applicable to persons working on contingencies, no, working on contract and were paid out of contingencies. However, she says that the recent memorandum dated 5th of March 2025 has allowed the casual employees whose names being duly verified by the district level verification committee and registered in PIMS may be granted scale pay as per ROP 2015 with effect from 1/4/2025. She as such, 1/4/25, I am going too fast I think. She as such submits that the present case may be disposed of in view of the said office memorandum. Heard the counsels? No, it's not over. Heard the counsels? In view of the said office memorandum dated 5th of March 2025, the work charge employees working in all the departments where in all the departments who were receiving fixed pay were directed to be granted scale pay as per ROP 2015. However, it was also stipulated in the said office memorandum that the said exercise would be done only after the names are verified by the committee concerned and whose names are registered in PIMS. I mean, your case will not be affected with this, with effect from 1/4/25. So now only you will get.
Yes, because Your Lordship, it's going in block, Your Lordship. So
Because you had prayed for arrears and all,
Yes,
but
Your Lordship.
your arrears will not come. You will be paid with effect from 1/4/25.
Yes, Your Lordship.
So I will dispose it of saying the concerned authority to consider your case according to the office
According to
memorandum.
the office memorandum.
Since the petitioner has prayed for granting him scale pay, the present office memorandum squarely covers his case. As such, this court directs the respondent authorities to consider the prayer of the petitioner in light of the office memorandum dated 5th of March 2025. petition is disposed of. Rest, if I make some something in between, I'll write. Because on equal pay for equal work, you need some, some deliberations on that. Not required because we are covered by this.
There's a memorandum, Your Lordship.
Not required. When it is not required, we need not. Because otherwise, if your responsibilities, duties are same, you cannot be paid lesser than the so-and-so, according to the Supreme Court. I'll write a one line there and then I'll finish this.
And Lordship, in the next case,
the other one is what? Same.
Lordship, here also, the petitioner is praying for scale of pay as well as regularization, Your Lordship. With regard to the scale of pay, same order can be passed. And as far as regularization is concerned, today I will not. Today I would like to only confine with scale of pay, Your Lordship. As far as regularization is concerned, liberty may be granted to approach this court at a later stage, because there are certain memorandums with regard to regularization also, Your Lordship. So I may be covered in the future, Your Lordship. So I will, liberty may be granted to appropriate.
As far as the regularization is concerned.
Yes, Your Lordship.
Okay, first part will remain almost the same. Second part you write, the petitioner prays that as far as the second prayer is concerned, petitioner submits, as far as the second prayer is concerned, no, the first prayer is concerned, that is, for a direction to the respondents to regularize the service of the petitioner, she may be allowed she may be permitted not to press the relief for the time being.
Yes, Lordship.
She may be permitted not to press for the relief for the time being, and that she would
liberty may be permitted.
You will file representations or what? No.
No, Your Lordship, there's already an office memorandum stating that after attending the 30 years, those who are enjoying the scale pay, automatically they can apply for regularization. So it implies it will be automatic. In fact, this
liberty may be granted to approach at an appropriate time, Your Lordship.
Only that?
Yes, Your Lordship.
Okay.
Otherwise,
it's automatic. It's automatic.
I know that notification. I think 17.3.
Yes, 2015.
But then there is another rider, 30 years of service.
Yes, Your Lordship. That's why.
Whether he has 30 years of service.
That's why till now they have not attended. So when they reach 30 years, this will apply. But as of now, it's not applicable now.
Okay, fine. Then as far as the second, she may be permitted what I've said, and a liberty may be granted to her to approach the Honorable Court as and when required.
Yes.
So the petition is disposed of. In respect of all this, I don't know which file will it go. Okay. This is the last matter.
Much obliged.
Thank you. Yes, thank you.